Councils, I have several things I'm going to mark as the next court's exhibits in order. One of them is a motion and limited was filed in regards to some regarding the redaction of out-of-court statements of D'Angelo White and law enforcement officers filed last night at 9:49 p.m. By Mr. Sharp on behalf of Mr. Stillwell. I'm also in possession of Defendant Williams' motion to adopt and add Stillwell's motion limine. Filed on 4/17 at 8:39 a.m. I'm also in possession of Mr. Williams' motion limine number 49, which talks about the PowerPoint slide presentation of some 105 pages that references it's entitled Operation Planners and goes through and has different slides that they're in. Okay. Okay, Mr. Shard, have you and the state worked on Mr. White's redaction? Mr. Shard?
Yes, sir. Turn on the microphone.
There you go.
I have spoken to the state about this issue, Your Honor. I identified two different, and we're not in agreement. I've identified two different portions of the tape. Overall, it's about a minute and a half that's in dispute. Probably, I believe that there's a hearsay statement at 6:48 of the phone interview. In the car interview, there's just basically what I feel is an argument of future dangerousness that's completely irrelevant, made by investigator Dennis. These, again, Your Honor, these are on tape statements made by D'Angelo White. Typically in trials, in my experience, prior statements are not just played to the jury. So, but I've noticed throughout this trial that the state, that is the way, their preferred method of impeaching their own witnesses. So if we're going to proceed on that method, which I don't necessarily agree with, I just think we need to clean up those two small areas. One area that has hearsay and one that has inappropriate argument of future dangerous.
How long have you had this particular recording, Mr. Sharp?
I've had it for over a year.
Why the motion at this point in time then?
Your Honor, I'm not articulating this correctly, I don't think. In trial, we have.
Well, I'm asking.
I'm explaining. Your
I'm asking you because here's the court's concern. You could have filed this as a motion months ago.
I wouldn't think that we were going to just.
No, that's not the point. If you think something's going to come up,
I didn't think it would come up.
Well, you filed it now, so you obviously because you've identified a course.
I've been sitting in trial,
Mr. Sharp. Mr. Sharp, because you've identified a course of behavior. So you should have filed it way before the witness is close to getting on the stand. Do you understand that?
The witness. Well,
let me ask you a question. Let me ask you a question. Do you practice in federal court?
No, I don't. But
I can tell you, this would not happen. This would not happen.
Okay. Your Honor, I don't think that the statements would be played in totality like this in federal court, quite honestly.
That may be true, but that does not relieve you of the responsibility to timely file a motion and it's just not wait till the last minute.
I'm not waiting to the last minute, Your Honor. I am not anticipating that we're about to discuss a slideshow.
Focus. We ain't got to that yet.
All right.
Focus. I'm focusing on your behavior at this point in time. I'm not saying to you that the information is not any less invalid, but it's the timing that's a problem. It's a problem, and since you
I
have,
wouldn't think that we would be admitting these things, but since I've seen these things, these statements, these out-of-court statements being admitted, I've taken it upon myself. A couple weeks ago, you said to us, please flag things in advance. I took
this
that
is
to
not
heart.
in advance. This is not in advance. This is like we got a jury sitting here. You all didn't get here at 1 o'clock. I told you to be here at 12:30.
I've been here.
I know that you were here early, and I know why you were here early.
Okay.
So, but focus. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time. Okay. So I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp, madam?
We did have discussions.
When?
Well, this morning.
That's too late. The evidence is excluded. The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that. And I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
We had no intention.
All right.
Reached out via telephone and called at least 2 members of the defense team and asked them to call me back. And I would like
but you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not gonna tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
Your Honor, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Sharp's got objections to it.
Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection at midnight. And then comes in and says,
well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude, and next time, make sure you're prepared. Make sure you're prepared next time. I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
we have talked to them. We have said we don't agree.
Then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that. Oh, it's going to be inadmissible right now.
I'm saying, Judge, that the court punishes the state because the defense.
I'm not punishing anybody, but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them last week, a whole week and a half ago, 2 weeks. Your
I'm
Honor.
not, well.
And I have asked, I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat. All right, ladies and gentlemen, please be seated. All jurors present, Sergeant Ingram.
All jurors present, counsel.
All right, ladies and gentlemen, jury, good afternoon. All right, without further delay, we're going to continue with the presentation of the state's case.
Your Honor, at this time, the state now calls, recalls to the stand, former crime scene detective, former crime scene technician, Lynette Roberts.
All right, Mr. Brown? Okay. All right, madam, come on up. Ms. Robertson, have a seat. You're still under oath, okay?
All right, good afternoon, Ms. Robertson.
Good afternoon.
Okay, on yesterday, we concluded the day, and I was going over some pictures as well as I presented you with another state's exhibit that we were going to go over. But before we go over that last state's exhibit, I want to go back to some photos that have already been admitted into evidence, starting with state's exhibit 30, Bravo, Bravo. And looking to the right, to the left of you, excuse me, my right, or going to the screen behind you. I want to ask you a bit about this particular photograph that you were saying. What are we looking at?
A hat?
Okay. And is this an item that you collected and took into evidence?
Yes.
Okay. I'll adjust this if it helps. Okay. And what, if anything, do you notice about this hat?
A hat with reddish brown stains.
Okay. And do you see reddish brown stains anywhere else in this photograph?
Yes.
Okay. Where do you see them?
On the ground.
Okay. Where on the ground do you notice now?
By a vehicle door.
Okay. Which door is that?
Passenger side front door.
All right. I'm now turning your attention to State's Exhibit 37, Bravo, Bravo. All right. Former CST Robertson, can you tell the jury what we're looking at here?
A hat with reddish brown stains.
Okay. And is it fair to say this is just a closer view of that last photo in State's Exhibit 30 that we looked at?
Yes.
Okay. I'm now going to turn your attention to State's Exhibit 36, Bravo, Bravo. Keep going. Just one moment. All right. If you zoom in, Senior A. Atkins. Okay. CST Robertson, what are we looking at here?
A hat with reddish brown stains and marker number 1.
Okay. What is the marker number? What is a marker number?
A marker number is marking your evidence.
Okay. And why would anyone use a marker number?
To mark their evidence.
All right. And is this item by marker number 1 something that you've included in your crime scene record pertaining to this case?
Have to
Sure.
look.
Sure thing.
You asked, would it be in my report?
Yes, is that in the report?
It would be in one of my photo descriptions.
Okay, and is it listed on the photo description in this report pertaining to this case?
Yes.
Okay, all right. Now I'm going to turn your attention to State's Exhibit 91. Bravo, bravo. One more. All right. What do we see in this picture, CST Robertson?
a picture of, I think, medical equipment on the ground.
Okay. And do you see any reddish brownish stains on any of that such equipment?
Yes,
Okay, where do you see it?
on the ground.
Okay, I want you to, if you could zoom in just a little bit, there, Senior Atkins. All right, and toggle down just a bit. All right, for identification purposes, do you see it on a blue object or a white object?
A white object.
Okay, all right, no problem. And I'm now going to direct your attention to State's Exhibit 39 Bravo Bravo. All right. Okay, all right, what do we see in this particular picture?
A photo of street signs.
Okay, and why would you have taken a photo of street signs?
Not only capturing the location if I was relocated from any area.
Okay, were you relocated in this case that you're here talking about now?
Yes,
And does this picture depict the area to which you were relocated?
yes.
And I asked you, what, if anything, occurred upon your relocation to this particular area as depicted in State's Exhibit 39, the Bravo Bravo?
Can you repeat that?
Sure, I'll ask it a better question. What, if anything, did you do upon being relocated to the area depicted in State's Bravo Bravo?
I took photographs.
And for completion's sake, can you describe the street names that are depicted in State's 39 Bravo Bravo?
Browns Mill Road, Harper Road.
Okay, and excuse me, I am now going to direct your attention to State's 40 Bravo Bravo. All right, and I'm not sure if that box is going to move slightly to the other side. Okay, no problem. CST Robertson, can you tell the jury what we're looking at here in State's 40 Bravo Bravo?
The intersection of Browns Mill Road and Harper Road.
Okay. Is it fair to say that this is just a wider view of said intersection that we looked at in state, the prior State's exhibit?
An overall view.
Okay, all right. And is it customary for crime scene technicians to take pictures of their relocation to different areas?
Yes.
Okay. All right, I am now going to turn your attention to State's 41. And Ms. Robertson, can you tell the jury what we're looking at here?
Another overall of Browns Mill Road and Harper Road.
Is this the opposite facing angle of the same intersection that you just reviewed in the last State's exhibit?
Yes.
Okay, all right, and I will now direct your attention to State's 44 Bravo Bravo. Okay, CST Robertson, and if you can zoom in just ever so slightly to you. Okay, what are we looking at here in State's Exhibit 44 Bravo?
You're looking at a cartridge casing.
Okay, and is this something that you located upon your relocation to the intersection that was discussed earlier?
Yes.
And is this a piece of evidence that you would have collected upon locating it at that said intersection?
Yes.
And what, if anything, do you do after locating such a shell casing?
Once I locate it, photograph it with the marker,
Okay.
process it for latent fingerprints.
Okay. All right. I'm now going to turn your attention to State's 45 Bravo Bravo. Okay, CST Robertson, is it fair to say that this is a closer view of the same shell casing that you located at the intersection of Brownsville Road and Harper Street?
Yes.
Okay, and can you describe the condition of this shell casing that we're looking at here in States 45 Bravo Bravo?
The condition as in,
I'll ask this question. Does it appear to have a dent or be bent in any kind of way?
it appears that way.
Okay, would you say that this is a spent, shell casing or unspent piece of ammunition?
I would say it's spent.
Okay, and when I say spent, what is it that I am just, what is it that, you understand that to me?
It was fired, it was used.
Okay, and I am now going to turn your attention to State's Exhibit 95 Bravo Bravo. Okay, CST Robertson, is this the same shell casing that we just looked at in the state's, prior state's exhibit?
Yes.
And in State's Exhibit 95 Bravo Bravo, is that, were you the one to place that evidence marker there, number 2?
Yes.
Okay, and is this indicative that this was something you collected and taken in there?
Yes.
Okay, and I'm now going to turn your attention to States 46 Bravo Bravo. Excuse me, 47 Bravo Bravo, my apologies. Okay, CST Robertson, what are we looking here at States 47 Bravo Bravo?
A cartridge casing.
And is this a different or the same cartridge casing that we looked at in the prior state's exhibits?
A different one.
Okay, and as with the last cartridge casing that we discussed, can you describe the condition of this particular shell casing that we're looking at in States 47 Bravo Bravo?
Spent casing.
Okay, and I'm now going to turn your attention to States Exhibit 52 Bravo Bravo. And if you just zoom in ever so slightly, Senior A.D. Atkins. There we go. Center, please. Thank you. And CST Robertson, can you tell the jury what it is that we see here? Is this the same shell casing?
The same shell casing as the last photo, yes.
Okay, and that evidence marker, is it fair to say that that evidence marker that is placed there is indicative that you took that shell casing also in the evidence?
Yes.
And with both shell casings that you collected in this particular case, is it also fair to say that you ran tests on both of them?
Yes.
And what was the test that you ran on?
I processed for latent fingerprints.
And did you find anything of value?
No.
Okay, and I'd like to ask you, did that conclude your involvement with this particular APD case number, which is APD 151022458?
Is this right here?
Yes, as to this particular APD case number, APD number 1510224.
Yes.
Okay, no problem. Thank you. And I am going to now briefly. Okay. I am now I'm approaching the defense, which has already been provided in the discovery process and has been pre-marked as State's Exhibit 62 India, Your Honor. Thank you, sir. Okay, Your Honor, at this time, I am now approaching Ms. Robertson, with State's Exhibit 62, India. Okay, Ms. Robertson, I've now handed you State's Exhibit 62, India. After having a second to look at it, I'll ask you a question. Couple of questions. Have you had enough time to review State's Exhibit 62, India?
Yes.
Okay. Ms. Robertson, can you tell the jury what State 62 India is?
My report from another shooting incident.
Okay, and how do you know what it is?
I'm looking at my report.
Okay, and has your report been changed or altered in any way since the first time, since when you authored it on January 9, 2015?
No.
Okay. Your Honor, at this time, the state now moves to admit State's 62 India into evidence.
Any objection, states India, states 62 India.
Yes, Your Honor. I object based on hearsay, based on confrontation clause. It would be cumulative to this testimony, but also be violative of the continuing witness.
Let's ignore the last one until it's, if it's admitted. Can I see it, please?
Sure, Your Honor, as with yesterday's.
All right, Mr. Adams, I'm going to overrule your objections. State 62 India is admitted.
All right, Ms. Robertson, and Ms. Robertson, I'm now approaching you with State 62 India, and I'm going to ask you a few questions. Based on your report, what day were you called out for service?
January 8th,
Okay, of what year?
2015.
Okay, so this is earlier than the incident that we just got through discussing that occurred on April 12th of 2015.
Yes.
Okay. What time did you get called out based on your report?
11:24.
Okay. And is there an APD case number associated with this particular incident on your report?
Yes.
Okay. And what is that APD case number?
It is 150-083-130.
As was the case yesterday, if you would be as kind to mark the poster board with that date under the appropriate month and year, or month and day, that case number, please. And Your Honor, I should have asked, the witness have continued permission to move about the courtroom.
She may, sir.
Thank you, Your Honor.
And it goes without saying, if any of the defense needs to relocate themselves, take a look or have a better vantage point, you're welcome to do so.
Okay, thank you. All right. Okay, I'm going to now direct your attention back to State 62 India. Can you tell the jurors, the members of the jury, the location to which you were initially called out as it pertains to this particular APD case?
675 Metropolitan Parkway.
Okay, Is that the address that you were first positioned at when you arrived at that crime scene, or is there ever a time that you relocated during this particular incident?
It's possible I relocated.
If you would be as kind to turn to the narrative portion of your report and read what it is that you noted at that day and time you took.
On January 8th, 2015, CSTL Robertson was called for service at the location of 1064 Metropolitan Parkway for an aggravated assault. I took photographs of the vehicle and of its damages. I was relocated to 675 Metropolitan Parkway where incident took place. I took photographs of another vehicle and of its damages. I collected 7 shell casings. The 7 shell casings were submitted into the APD crime lab for further processing. See attached photos. No further requests were made.
All right, so I'll ask you now again, since that you had an opportunity to read the report, was there a time that you was there a location to which you initially responded?
Yes,
And was there a second location within that incident that you were there to process that you responded?
I stand the objection.
I'll rephrase, Your Honor. Can you tell the jurors today what addresses you responded to for this particular case?
1064 Metropolitan Parkway.
Okay, and what was the second that you read?
675 Metropolitan Parkway.
Okay, and excuse me. In what county are those locations located?
Fulton County.
Okay, and when you responded to the first address, can you tell the jury what, if any, evidence you collected at that time?
Photographs and I believe vehicle damages, photographs of the vehicle damages.
Okay, and when you responded to the second address for this incident, can you tell the members of the jury what, if anything, you did at that time?
At the second location, I took photographs. I took photographs of the damages to vehicles as well as collected cases.
Your Honor, at this time, the state is now approaching the defense with state exhibits 1 India, to states exhibit 61 India, which have already been shared in the discovery process and have been pre-marked as well. All right, excuse me. I am now approaching you with states exhibits 1 India, to 61 India. And after you've had a chance to look over those, I kindly ask you to look up at me and then I'll ask you some further questions. Yeah, okay, you had it. I see you looked up at me. Does that mean that you finished everything?
Everything?
All right, no problem. Okay, and what is it that I have handed you as states exhibits 1, India, India to 61, India, India?
Repeat the question.
I actually can. What have I just handed you that has been pre-marked as states 1, India, India to 61, India, India?
Photographs of crime scene.
Okay, do you recognize those photographs?
Yes,
How do you recognize them?
I took these photos.
All right, and have those photos that you looked at been altered in any way since the day that you initially took them?
No,
Do they fairly and accurately depict the location of the crime scene that you responded to on the day on the day of January the 8th, 2015?
yes,
Okay, Your Honor, at this time, I now move to admit states 1, India, India to states 61, India, India.
Any objection to states 1, India, India to 61, India, India?
No, sir, no objection.
All right, they're admitted, may be published as you see fit.
Thank you, Your Honor. Ms. Robertson, I'm going to turn you back to your crime scene record that pertains to this particular incident that you responded to. That has been noted as states exhibit 62 India. And I'm going to turn you to the page that pertains to the photos descriptions that you listed here through 1 through 61. And I would ask that you would kindly read what it is that you did, your photos correspond to in this description. Kindly.
are we starting with photo number 1?
Yes, so I'll direct you. Sorry. Yes. Until you.
Photo number 1, close-up of street signs. Photo number 2, overall on the backup of the Chevrolet vehicle. Number 3, mid-range of back of vehicle. Number 4, close-up of vehicle tag. Number 5, overall of driver's side of vehicle. Number 6, close-up of front of vehicle. Number 7, overall of passenger side of vehicle. Number 8, overall of back of vehicle. Number 9, overall of rear window damage. Number 10, mid-range of rear window damage. 11, close-up of rear window damage. 12, overall of passenger side rear window damage. 13, overall of passenger side rear window damage. 14, mid-range of passenger side rear window damage. 15, close-up of passenger side rear window damage. 16, close-up of passenger side rear window damage. 17, close-up of vehicle VIN number. 18, overall of location. 19, close-up of address. 20, close-up of address number. 21, overall of name of location. 22, overall of back of vehicle. 23, close-up of vehicle tag. 24, overall of driver's side of vehicle. 25, overall of driver's side of vehicle. 26, overall of passenger side of vehicle. 27, overall of passenger side of vehicle. 28, overall of rear window damage. 29, overall of front of vehicle. 30, overall of rear window damage. 31, mid-range of rear window damage. 32, close-up of rear window damage. 33, close-up of rear window damage. 34, overall of shell casings. 35, overall of shell casings. 36, overall of shell casing. 37, close-up of shell casing. 38, mid-range of shell casing. 39, close-up of shell casing. 40, overall of shell casings. 41, mid-range of shell casings. 42, close-up of shell casing. 43, close-up of shell casing. 44, mid-range of shell casings. 45, close-up of shell casings. 46, overall of shell casings with markers 1 through 7. Overall, 47, mid-range of shell casings with markers 1 through 7. 48, overall of shell casings with markers 1 and 2. 49, mid-range of shell casings with markers 1 and 2. 50, close-up of shell casing with marker 1. 51, close-up of shell casing with marker 1. 52, close-up of shell casing with marker 2. 53, close-up of shell casing with marker 2. 54, mid-range of shell casing with marker 3. 55, close-up of shell casing with marker 3. 56, mid-range of shell casing with marker 4. 57, close-up of shell casing with marker 4. 58, mid-range of shell casing with marker 5. 59, close-up of shell casing with marker 5. 60, mid-range of shell casing with marker 6.
All right.
You want me to do 61?
Yes, ma'am.
Close-up of shell casing with marker 6.
Okay. I'm now going to turn your attention back to when you relocated from the 64 Metropolitan Parkway to the 675 Metropolitan Parkway address. Upon relocating to the 675 Metropolitan Parkway address, how many shell casings did you recover from that location, according to you?
Okay, I'll take a look. According to the report, 7 shell cases.
And according to your report, can you tell the jury, excuse me, just a second. Were fingerprints done on these shell casings as were the case in the first APD case number you responded to?
Yes.
Okay, and was anything of value found from those shell casings?
No.
And in your report, as it pertains to the window damage that you noted, when you say damage, what kind of damage are you describing?
Defect damage from shootings.
Okay, and based on your report, how many vehicles had defects?
2.
Okay, do you know anywhere in your report what those vehicle types were?
Yes.
Okay, tell the jury what those were according to your report.
I'm gonna look real quick. Chevrolet Silverado and a GMC 150.
Okay, and as it pertains to this particular case, after I strike that, did you in fact collect those 7 shell casings that you observed on at the 675 Metropolitan Parkway address?
Yes.
And what was done with those shell casings, if anything, after you collected them?
I collected them and processed them for like fingerprints and turned them into the APD crime lab for further processing.
Right. And did that conclude your involvement with APD case number 150, 150 one second. 150 150083130.
Yes.
Okay, and I am now going to turn your attention. Well, before I do that, I'm now approaching the defense with what has already been pre-marked as states 23 Foxtrot, and has already been served in the discovery process, Your Honor. All right, Your Honor, I am now approaching the witness with this pre-market states 23 Foxtrot. Ms. Robertson, would you please take a look at what it is that I just handed you? And once you're done reviewing it, please look up at me. Okay. Ms. Robertson, what have I just handed you?
Report.
Okay, and what type of report is this?
Hang on a second.
Sure.
A shooting incident.
Okay, is this a report you authored?
Yes,
And how do you know that you've authored it?
my name is on it.
Okay, and is that report that I handed you, that your name is on, is it the same or is it in the same or substantially same position as it was at the time that you authored it on January 23rd, 2015?
Yes,
Okay, Your Honor, at this time, the state now moves to admit into evidence State's Exhibit 23 Foxtrot.
Any objection to states 23 Foxtrot?
Your Honor, in regards to that exhibit, my objection to the same previously contains hearsay. It is cumulative witness testimony that it violates compensation, not compensation obligations, and at another time, depending upon court's ruling, it may be violative of the continuing witness.
Let's not, I prefer not make that last objection because that depends on a lot of other things that haven't come to pass. So I'll consider the first ones. Can I see it, please? All right. All right, Mr. Adams, I've noted your objections. I'm going to overrule them. States 23 Foxtrot's admitted. Continue objection.
Thank you, kindly. I am now approaching the witness with State's 23 Foxtrot. And CSD Robertson, can you tell the jury what, if any, APD case number is associated with this particular document?
150-222-838.
Okay. And as, well, what date is associated with this particular incident?
January 23rd, 2015.
Okay, and is there a location associated with this particular incident?
Yes,
And would you be as kind as with the case before and take that black marker and note on the poster board the APD number associated with the pertinent date for the timeline? Just a brief indulgence, Your Honor.
Yes, sir.
All right. Ms. Robertson, I am now back with you. I want to ask you about your report. On your report, what is the type of incident that you called out for?
for a shooting.
Okay, And according to your report in the narrative section, which you will see if you flip the report a few pages over, would you be as kind to read that portion of the report for the jury's hearing?
Excuse me.
Subject to witness simply reading the report after testify who is what is supposed to read.
I stand in objection.
Your Honor, if I may respond.
Go ahead.
It's in evidence, Your Honor.
I know, but it might just go a little bit better if you do that.
Sure thing, Your Honor.
Okay.
All right. CSC Robertson, can you tell the jury, based on the narrative portion of your report, what it is that you did when you arrived to the 1007 Hill Street address?
Took photographs.
Is that all you did?
No.
What else did you do when you were responding to the 1007 Hill Street address, based on your report? You can refer to it, you just can't read from it.
Okay. I collected handguns.
Okay. What did you do after you collected those handguns, according to your report? You may refer to.
I processed 3 GSR kits, which is gunshot residue kits, on 3 suspects.
Okay. And what address?
At the Zone 3 precinct, 215 Lakewood Way.
And, excuse me, just briefly. And what is the purpose of a gunshot residue kit?
To see if there's any gunshot residue in your vicinity, on your person, particles, dust, anything around you.
Okay. And how does that process of testing for that operate? How do you do that?
It's a kit. You open the kit and follow the directions.
Okay. All right. Just a brief moment. All right. I am now showing defense counsel what has already been pre-marked as States Exhibit 1, Foxtrot, to States Exhibit 22, Foxtrot. These documents have been pre-marked and already served prior to the discovery process. I am now approaching the witness, Your Honor, in States 1, Foxtrot, to States 22, Foxtrot. Ms. Robertson, after you take a moment and review those to yourself, and you've done so, look up at me and we will continue talking. handed you, Ms. Robertson.
Photographs?
Okay, and are those photographs that you taken?
Yes.
And how do you know? Do you recognize them?
Vaguely.
Okay. And have those photographs been, do they fairly and accurately depict the crime scene as it was on the day that you responded on January 23rd, 2015?
Yes.
Okay, and Your Honor, at this time, the state now moves to admit states, excuse me, 1 Foxtrot, 2 22 Foxtrot.
Any objection to states 1 Foxtrot to 22 Foxtrot? Anyone?
No, sir. No, sir.
All right, they're admitted and may be published as you see fit.
Thank you, Your Honor. Ms. Robertson, I would like to ask you to photographs that have just been handed to you, pre-marked as states exhibits 1 Foxtrot to 22 Foxtrot correspond to the photographic narrative contained in your report for this case.
Yes.
Okay. I would also ask you, as it relates to the set of photographs that we reviewed prior to these that were pre-marked as states exhibit 1 India to 61 India. Do those particular photographs correspond to the photographs contained in the earlier report that we reviewed secondly?
Yes.
I would also ask you about the photographs that have been pre-marked as states exhibits 8BB, Bravo, to 53 Bravo, and 80 Bravo to 97 Bravo. Do those photographs that we reviewed first correspond to the photographic narrative contained in your first report that we reviewed?
Yes.
All right. Just a few more questions here, Ms. Robertson. I want to turn your attention back to the second APD incident that we discussed a few moments ago. And if you would just indulge briefly, I'll ask you a few questions pertinent to that. Pertaining to the second APD incident that you responded to, do you, in your report, note who the purple truck belongs to?
No.
Okay. Would you take a look at your report and tell me if you see any such notes?
Excuse me. No.
Okay. I'm going to ask you just maybe a few more questions here. Do you know a man who goes by the name of DeQuantes Lamar, or AKA Rich Homie Quan?
No.
Did you speak with anyone by that name or alias at the scene of the crime that you responded to on that day?
No.
And to be specific, let me say on the day of January the 8th, 2015?
No.
Okay. And do you know an individual named Donovan Thomas, also known as Peanut?
No.
Did you interact with anyone by that name at the scene of the crime on that day?
No.
Your Honor, I have no further questions for this witness.
Cross.
Robson, good afternoon, sir.
Good afternoon.
You hear me okay?
Yes.
All right. I've got a couple of questions for you in regards to what you just testified to previously, okay? If I heard you correctly, you were a crime scene technician back in, I'm going to start first with the April 12th day. April 12th, 2015, you were a crime scene technician with the Atlanta Police Department. Is that true?
Yes.
You were called out to a location at Fremont. I think you said 1987 Fremont Avenue. Is that right?
Yes.
And of course, you were not involved in the initial investigation, you came there specifically for the purpose of collecting evidence.
Repeat that.
All right. When you came to the location as a crime scene technician on April 12, 2015, you were there to document and collect evidence, true?
Yes,
Because that's what you were doing at that point. That was your role, correct?
correct.
Okay. So you get to the location, and the only thing that you know is that there are things at Fremont, this Fremont location that you've got to document and take pictures of, correct?
Correct.
All right. Now, you're not a detective, right?
Right.
You wouldn't be charged with talking to individuals, right?
Correct.
The only person really you'd be interacting with would be either the detective or the officer that's there at the scene telling you what items you should focus on, correct?
Correct.
That notwithstanding, did you actually talk to anyone at the location when you got there?
Objection calls for hearsay, Your Honor.
I stand objection.
Well, I'm not asking what anyone said, I'm asking if did you speak to anyone on that day when you got there?
Yes.
All right. Would it be just officers, or did you speak to lay people, to regular citizens?
Officers.
Okay, so you spoke to no lay persons when you got there, just police officers, correct?
Correct.
Now, when you got to the location, and then we saw pictures earlier of the vehicle that you photographed, there was no one in the vehicle, correct?
Correct.
All right. Police officers had been there already, true?
True.
You didn't have any idea whether the incident that left the defect in the front of that vehicle happened at Fremont or happened at the other location of Brownsville. You didn't know that.
Objection, Your Honor, calls for speculation.
Stand objection.
Did you know where that defect, where the vehicle was when it got that vehicle?
Calls for speculation, Your Honor. I'm objecting.
I stand the objection, Mr. Fulton.
All right. When you got to Fremont, the vehicle already had the defect in it, true?
Yes.
All right. Now, I want to ask you specifically about some of the things that you were tasked to do. Although you started at the Fremont location, you ultimately ended up going to the corner of Browns Mill and Howard. Is that right?
Brownsville and repeat that?
Did you end up going to a different location after Fremont?
Yes.
Okay. What was that second location that you went to?
I'm gonna tell you the exact location. I was relocated to Browns Mill Road at Harper Street.
Okay. And that was the direction of a law enforcement officer?
Yes.
With the state's assistance, I want to pull up some of their photographs that were shown earlier. Do you have those? Let's start with 12 Bravo Bravo. And I want you to take a look at that when it comes up on the screen for us, okay? By the way, do you have your reports in front of you, Ms. Robson?
Yes.
That's it, Judge?
You may.
All right. Robson, I want you to take a look at the screen and tell me if that is the scene that you looked at earlier and described as the front of a vehicle or the vehicle that you photographed. Is that what it is?
Yes,
All right. So when you get to the location, you see this vehicle, and it is exactly as it looks right there, correct?
yes,
You didn't open the doors.
no,
You didn't put that hat on the ground.
no,
You don't know how it got there.
no,
You don't know who had it on before you got there.
no,
You don't know how it got on the ground.
no,
Now, there was no one in the car, right?
correct,
And you looked through the car. You searched it, right?
correct,
You didn't find any guns in the vehicle.
no,
You don't know whether there were any guns in the vehicle before you got there.
no,
Objection calls for speculation, Your Honor.
I stand the objection.
Because you came there after the fact, you don't know if there were any guns in the vehicle. True?
true,
You are not in a position, because you weren't there prior to this scene, to say how many people were in the vehicle before that. True?
true,
You don't know how the vehicle got from Browns Mill to the Fremont location, right?
right,
Let's look at 27 Bravo. 27 Bravo, right next to you, Ms. Robinson, is the front of the vehicle that you photographed, is that right?
photograph of the windshield, the defect,
When she was in front of the vehicle, right?
correct,
Now, of course, by the time you got there, that defect is already there, right?
yes,
You don't know how it got there, true?
true,
You don't know what was happening at the time that bullet went through that windshield, right?
right,
Because you got there at this point, where you're looking at the vehicle, you don't know what anyone inside of the vehicle was doing at the time that bullet came into the vehicle, do you?
no,
You were asked a lot of questions about whether or not the window, the driver's side window and passenger side window were either up or down. Remember those questions?
yes,
In these photographs that you were shown, the windows appear to be up. True?
true,
All right. Now, it is fair to say that since that's the position they were in when you got there, you don't know whether they were down sometime before that, right?
right,
You don't know who, if anyone, manipulated the windows at any time before you got there. True?
Objection.
That's not an evidence. I stand the objection.
That's not an evidence.
I stand the objection, sir.
Do you know whether the car was ever at Browns Mill and Harper?
repeat that,
Do you know whether this car that you photographed was ever at the corner of Browns Mill and Harper?
no,
And so you wouldn't know whether or not it traveled from Browns Mill and Harper to Fremont, and if so, how we got there, right?
no,
Can I see a 15 Bravo, please? All right. Bravo that you're looking at over to your left, Ms. Robinson, is this vehicle with what appears to be what you describe as blood stains on the ground, true?
yes,
Blood stains on the interior of the car, correct?
Yes,
Bloodstains on the door, the passenger door of that vehicle, right?
right,
Now, when you show up as a crime scene technician, you can collect evidence, right?
right,
And there are certain things that that evidence can tell you. You agree?
right,
The evidence can tell you, for example, whether or not it appears as though a gun was fired inside of the vehicle. For example, if you find shell casings, that might be an indication that a gun was fired in the vehicle, right?
right,
Or it might not. Gun may have been fired, there just are no shell casings in the vehicle, right?
right.
Gun could have been fired from a revolver where there's no ejection of a shell casing, and then you don't see any shell casing in the vehicle, right?
I'm going to object, Your Honor. This is facts not in evidence too.
I stand the objection.
You didn't find any shell casings in the vehicle, right?
Right,
But that doesn't tell you whether or not the gun was fired in the vehicle or not, correct?
correct.
The photographs that you take, the items that you collect, that evidence isn't capable of telling you who was in the car, right?
I wouldn't know who would be in the car, no.
Right,
It would be sent to the lab to confirm.
right. You wouldn't know what anyone was doing in the car, right?
No,
You wouldn't know the motivations of anyone in the car at any point, right?
right,
Objection, cause for speculation.
I stand the objection.
I mean,
Let's move on, sir.
crime scene collection can assist in collecting physical evidence, right?
right,
What it can't do is pass upon the motivations or the actions or the reasons that people in this car may have done what they did, right?
right.
Objection, that's not an evidence. Motion to strike.
Motion to strike.
I stand the objection, Mr. Adams. It's an improper question. Ladies and gentlemen, don't disregard the last question and the answer to it. Let's move on, sir.
Were you ever tasked with going to the Citgo gas station on that evening?
What's the address for the Citgo?
Well, did you go to a Citgo gas station regardless of what the address is?
I don't know. I don't recall.
You don't know, or you don't recall?
I don't recall.
Were you ever shown any video surveillance from a Citgo gas station?
I don't recall.
Mr. Atkins, can I have 39 Bravo, please? That's the location that you went to after you left the Fremont address, is that right?
Yes,
What's the distance from the Fremont address to, Browns Mill and Harper Road location?
I don't recall.
I told you it was a couple blocks. Are you in a position to say yes or no?
Objection, Your Honor. Witnesses already indicated.
I stand the question.
All right, could you make a notation of the distance between the Browns Mill and Harper location to the Fremont location and anywhere in your report?
Nothing located in my report about that.
So you went there because one of the officers of the Texas told you to go there and take some photographs, all right?
Correct.
Do you remember who the detective was or the officer was that you were dealing with that night who was giving you the instructions on it?
I don't recall.
That's my evidence.
Overruled.
Can I have a 41 Bravo Bravo? The photograph that you're looking at right now, Ms. Robinson, that's the Browns Mill and Harper location, is that right?
Yes,
Now, as you were taking photographs of this intersection, did you know what the significance was of this related to the vehicle that you were taking photos of earlier?
you said, did I know what?
Yeah.
Repeat that one.
What's the significance, right, of this intersection that you were taking photographs of?
So shooting and some cartridge casings.
Okay. Were you of the opinion or were you of the knowledge that there was a shooting that had taken place at this location?
I was relocated to this location.
So someone just, one of the officers, whoever it was, just told you, go to Brownsville and Harper and go take some photographs, see what you find?
One of James' characterization calls for hearsay, Your Honor, as well.
I'll sustain that as the form. You can rephrase, Mr. Adams.
Let's see, 45, Bravo, you don't like that. All right, shell casing, one of two found at that location, is that right?
Vague, Your Honor.
Say again, sir.
Objection vague.
I'll sustain the objection. You can rephrase.
Okay. The shell casing that is depicted in State's Exhibit 45, Bravo, is a shell casing that you took a photograph of, is that correct?
Correct.
You took a photograph of two shell casings, is that right?
Correct.
This is one of them, right?
Correct.
This is one of the two photographs, the two shell casings that you took photographs of, right?
Correct.
You don't know anything about, well, I heard you say that they were analyzed for fingerprints.
Yes.
Did you do that?
Yes.
And were the results made part of your report?
Yes.
And they were negative for fingerprints, is that right?
Correct.
And so other than finding two shell casings at that location, there was nothing else of evidentiary value related to these two shell casings, correct?
You have my report, but it's correct.
Answer yes.
You have my report, yes.
Well, you remember what happened when you examined the scene and took photographs and took evidence, right?
No, I told you I don't recall. You have my report, and I can answer your question. You give me my report.
Okay. So in order to tell us anything about that night or your investigation, you need to see
Refer to
the
my report. Yes,
because
correct.
you don't have any independent recollection of it, right?
I'm gonna object, Your Honor, asked and answered.
I'll rule the objection.
What about evidence of any blood at the location? And when I say location, I'm talking about the Harper and Brownson. Did you find any indication of any blood there?
No.
Any cameras at that location? Traffic cameras? Anything like that?
I don't recall.
Were either you or anyone else with the Atlanta Police Department who was investigating this crime, the shooting that night, tasked with checking to see whether any homes right there at that intersection may have had any cameras, ring cameras, anything like that?
I'm sure the detectives did.
You sure that they did?
Yeah.
Okay. Do you know for a fact that they did?
No.
I take it you did not, though, right?
No.
And would I also be correct that grounds of the location that you would have interacted with. Sure.
True.
Let me go back. I want to ask you a question about the vehicle that you photographed. And Ms. Atkins, if you could go ahead and put up 10 Bravo Bravo for me, please. I can throw up some question about that. Do you recall, and I'm not sure whether you can, if you can't see it from this photograph, I want to just ask you based on what you remember from that night, if you remember anything, whether or not the front passenger window was slightly open or slightly cracked when you got there.
According to the pictures, it was slightly down.
Atkins, do you have the 91 Bravo Bravo? By the way, let me ask you something. As a crime scene technician, if items are taken from individuals at a crime scene, right, would those items ultimately end up in your possession, or would those go with someone else?
Can you repeat that?
Yeah. At a crime scene, I'm gonna ask you generally now, but this is in your experience as a crime scene technician. At a crime scene, let's say there's an individual who is connected to a crime scene, and let's say a gun is taken from that individual. Would that gun then be turned over to you?
Yes.
In this case, when you arrived at this location, there were no items retrieved from anyone that were turned over to you, right?
Right.
When you got there at the location, at the person who had been shot, the person was already gone, right?
Yes.
Okay. Any other individuals around?
I don't recall.
In 91 Bravo Bravo, it's a picture of the back of the car, all right?
The ground.
Right. But if you're looking a little bit further on the car itself, it looks like the door is closed. Right? You know what I'm talking about?
Yes.
Driver's side, front door closed, right?
Yes.
Was this picture taken before the pictures of the interior or after?
I don't recall.
Like, who closed the door?
I don't recall.
Was it closed when you got there, or was it closed after you got there?
I don't recall. What does the picture say?
So when you testified earlier, when we showed you the picture of the car with the doors open, and you said that's the way the car was when you showed up, you don't really recall whether that was the case or whether the doors were closed, do you?
I don't recall.
Okay. Fair to say that in order for a door to be open at one point, closed at another point, somebody had to have closed the door, manipulated the door, right?
Objection, characterization.
I stand the objection, Mr. Form.
In order for a door to close, if it's open, someone has to close it, right?
Yes.
In order for a door to open, if it's closed, someone has to open it, right?
Yes.
Were any medical personnel on the scene when you arrived?
Not that I recall.
so in regards to this incident, it is true that you responded and took photographs, right?
Yes,
The car was located at this 1987 Fremont location, true?
yes,
You don't know how or if it got from, or why it got from the Harper and Brownsville location to Fremont. You don't know that,
Put
right?
objection, ask and answer, Your Honor.
I stand the objection.
You don't remember whether or not the door opened or closed when you got there, true?
Objection, ask and answer.
I
Your Honor.
stand the objection.
All right. I want to move on and ask you some questions about the incident that you talked about in Metropolitan Park.
Mr. Adams,
Yes, sir.
can we pause right now? Ladies and gentlemen, want to take a comfort break? Okay, we're going to do that, Mr. Adams. You can resume as soon as we're done. All right, ladies and gentlemen, let's take 15 minutes, okay, and then we'll come back. Madam, I'm going to excuse you as well, okay? 15 minutes to come back, all right? All rise. Tell her. Huh? Please. Please do. Talk to her about it. All right, ladies and gentlemen, our jury has left us. I'll see y'all in 15 minutes, okay? All right, we're in recess. Here, sir.
Let's see. Yes. Everybody is. No. Oh, there's Miss Westmoreland back there.
Yeah, she's back there.
Right, person count.
All right, can we recall Ms. Robertson, please? All right, Sergeant Ingram, summon our jurors, please, sir. Hey, Chris. And the next one's in order. Next one's in order. All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, Mr. Adams, you may continue, sir.
Carson, there was a question I was moving on to one of the other locations, but I want to jump back to that 1987 Fremont location for a second. When you got there, you testified that you got there and you photographed and collected evidence in regards to the car. Is that right?
I took photographs when I got there, yes.
Okay, the house, the location that you got to, 1987 Fremont, and we saw the, I guess the mailbox with the address on it, right? You remember that?
Yes,
And that was in fact the mailbox to that house, 1987 Fremont.
yes.
Did you ever, or were you ever instructed to go in that house to look for or collect any evidence in that house?
No,
Were you ever instructed to even take any photographs of either the front of the house or anywhere inside of the house of anything that might be of any evidentiary value?
I took photographs of the front of the house, but no, I wasn't directed inside of the house.
Do you know whether any of the officers who were there were interacting with people inside of that house?
Objection, speculation.
I stand the objection.
Do you know?
Same objection, Your Honor.
I'll overrule that one.
I'll even phrase it a different way. Did you observe any of the officers who were there on the scene interacting with anyone at that 1987 Fremont location?
I don't recall.
Okay. Let me move on then and ask you some questions about one of the other locations that you testified about. One of them was Hill Street. All right, I'm gonna leave your report there so you can take a look. You can reference it if you need to, okay?
Okay,
You were called out to Hill Street and you described it as you're responding to a report of a shooting. Is that correct?
Correct.
Information that you had is that there was a house that was supposedly shot at. Is that right?
I don't recall.
Okay. Do you remember who made the call?
I don't recall. No.
All right. Do you remember the name of the individual whose house you were responding to?
No.
Okay. How about your report? Look at your report and see if that helps refresh your recollection. If you want me to point you to it, I can do that. But you go first. Take a look and tell me if that refreshes your recollection.
Of whose house it is?
Yes, ma'am. The house that you were there in front of.
No, I don't recall.
Okay. May I, Judge? I'm sorry.
You may, sir, yes.
Okay, and this is your report, right?
It is.
This is a report that you prepared?
It is.
I presume you had a chance to review it for your testimony today?
No.
Okay, so you were brought in here by the DA's office without even having a chance to look at the report that you were going to come in here and testify about in this case?
When the questions come up of the report, then the report would be in front of me or made available for me.
Okay. All right, so this is your report. It's already been entered into evidence as Foxtrot 23 or 23 FF.
Correct.
I want you to look at page 2 of your report, the one that you said you prepared, right?
Correct.
All right. Right at the top, does it have something that talks about involvement?
Correct.
Does it talk about a crime scene?
Correct.
And does it have a name?
Correct.
Okay. Is that Frida Reed? Is that the name?
That is a name. Correct.
Okay. Take a look. I'm looking at that for you, okay? Did you, at this location where you had been advised that there was a shooting at a house, did you take pictures of the house where there was supposedly a shooting at?
No. According to the pictures.
Because they're in that stack of pictures, which are pictures that you took.
Correct.
There are no pictures of a house that was supposedly shot at that you responded to, right?
Correct.
What was there was a vehicle with 3 individuals in it. Is that right?
Was a vehicle. Correct.
And you were asked to take photographs of the vehicle and the contents of that vehicle. Is that right?
Correct.
Did you take photographs of the 3 individuals who were in the vehicle?
I don't recall. No.
Okay. What about this? You said that GSR, gunshot residue. Remember being asked some questions about that earlier?
Yes.
And at this location that you had responded to, your information was that there had been a shooting, right?
According to a report, yes.
You did not find any shell casings outside this house that had supposedly been shot at, did you?
No.
Because if you had, you would have photographed them and collected those shell casings, wouldn't you?
Correct.
And if you had seen any bullet defects on this house that had supposedly been shot at, you would have photographed those bullet defects, wouldn't you?
Correct.
Because that would have been important in the investigation, true?
Correct.
It certainly would have corroborated that a house had been shot at that you had responded to, true?
True.
Okay. What you did do, though, is that you photographed the trunk and interior of this vehicle in these photographs that have been labeled States Exhibit 1 Foxtrot through 22 Foxtrot, right? And in that vehicle, there were some guns found, right?
Correct.
So you got a vehicle, 3 guys in it, and 3 guns that you collect, right?
Correct.
Okay. Now, it wasn't done at the location, but I think I heard you say earlier that at Zone 3, you were the one who did the gunshot residue test on those 3 individuals, right?
Correct.
And I think if I wrote down your response correctly, you said there's really not a whole lot of technicality to it. There's a kit. You open the kit and you follow the directions, right?
You read the instructions and follow the instructions, yes.
Okay. Now, the individual, and you were the one who was actually interacting with these three individuals who were in that car where those guns were found, right?
Interacting,
Well, I mean, you had to interact with them in order to
this
right?
process the gunshot residue kits.
Right. I mean, you have to interact with the individuals, right?
The process,
Okay. So, Kelvin Watts, Jermaine Hardiman, and Jamal Baines were the three individuals who you did the gunshot residue test on. Isn't that right?
I don't recall.
You don't remember the names?
I don't recall.
Did you put it in your report?
I don't recall.
You don't. Well, it's in front of you. Take a look and see if it's in there.
Okay, hold on 1 second. There's only one name on my report.
Okay. What were the results of the gunshot residue test?
I don't have that either.
You don't recall?
Maybe the GBI does,
Okay.
because that's where the gunshot residue kits go.
Okay. And so at any time after you performed the test, I presume you sealed it, right?
Correct?
Okay. You were never advised of what the results were?
No.
Okay. The other incident that you were asked about, let's see, that would have been the Metropolitan Parkway incident. And that is the one where you took photographs that have previously been marked, identified, and entered as State's Exhibit 1, I guess that's indigo, to 61 indigo, right?
Yes.
Okay. You responded to that location because there was, the information you had was that there had been a shooting out front of a location, correct?
Correct.
Not a shooting of a person, but just a shooting period, all right?
Correct.
And there were vehicles that had sustained some bullet, what you determined to be bullet defects, right?
Yes.
Okay. You took photographs of them.
Yes.
You collected shell casings.
Yes.
A total of how many?
7.
7 shell casings found where outside the location that you responded to.
Yes.
And refresh my memory, what was the address of that Metropolitan Avenue location?
675 Metropolitan Parkway.
675 Metropolitan Parkway. That is a business establishment, is it not?
According to the pictures.
Okay. And would I be correct that, as in the previous cases, you did not personally interact with any individuals, witnesses or otherwise at that location?
Correct.
You just took photographs of the vehicles that had some damage to them, yes?
Correct.
And you scoured the area and found some shell casings and collected those, right?
Correct.
All right. All right. One moment, please, Judge.
Yes, sir.
Thank you, Judge. That's all I have.
Mr. Sharp, go ahead.
Good afternoon.
Good afternoon.
I'm just going to ask you a couple questions about the April 12th, 2015 work that you did, okay?
Okay.
All right. I noticed all the photos that you took were outside, correct?
Yes,
And when I say outside, outside the residence of 1987 Fremont Avenue, correct?
correct.
Okay. And that vehicle that was parked in front, it was parked right in front of Fremont, 1987 Fremont Avenue, correct?
Correct.
Okay. You never entered 1987 Fremont Avenue, did you?
No,
And to your knowledge, no law enforcement ever searched inside 1987 Fremont Avenue in search of any guns that may have been discarded there, did they?
I'm going to object to
Basis.
speculation.
I asked to her knowledge.
It calls for speculation, Your Honor.
Yeah, it does. I'm going to sustain the objection.
Are you aware of any law enforcement searching that house for discarded firearms?
Same objection.
Same, yeah. Sustained.
No further questions.
Anyone else? Any redirect, Mr. Brown?
I have a few questions for you, Ms. Robertson. On cross-examination, when you were asked a few questions by Mr. Williams's attorney, Mr. Adams, and he asked you if you searched for any surveillance cameras. Do you recall that question being asked of you?
yes.
When you respond to a crime scene, what is your primary purpose for responding?
Process the crime scene?
Okay. Are you responsible for looking for crime scene surveillance footage?
No,
Upon us responding to a crime scene, is it customary for crime scene technicians to take pictures of property or things involved in the crime scene prior to moving?
no,
Okay. Is it, excuse me, earlier you were asked a question on cross by Mr. Adams about how the vehicle was moved or where it came from. When you respond to a crime scene, is that part of your responsibility to know how a particular piece of property arrived to where it did?
no,
Is knowing who was in a particular vehicle a part of your investigation?
no,
Are officers required to preserve a crime scene prior to your arrival? Excuse me.
yes,
Earlier, you were asked some questions with respect to blood that was found at the location pertaining to the first incident occurring on April the 12th, 2015. I want to reorient you to that. You were asked by Mr. Adams if you found any blood near the intersection of Harper and Brownsville Road. Do you recall that question?
yes,
And your answer was no, you didn't find any blood in that location. Do you recall that?
yes,
But did you find blood at the 1987 Fremont address near the blue vehicle?
yes,
Did you find any blood inside that vehicle?
yes.
Where was the blood that you recall finding at that location?
At 1987,
Yes, ma'am.
on the ground and in the car.
I want to go and redirect you to a few other questions that you were asked on cross. You were asked if you went into the 1987 Fremont address. Do you recall that question being asked by Mr. Adams?
Yes,
Were you aware at that time of any of the 1987 Fremont address, the residence at that address being involved in this particular shooting incident?
no,
Would you have had any reason with that knowledge to go into 1987 Fremont Street to take pictures of someone's home?
no,
Just briefly, Ryan. Earlier, you were questioned about whether you spoke with anybody when you arrived to the 1987 Fremont address. Do you recall those questions?
Yes.
Is it your responsibility to question anyone upon your arrival to a crime scene?
Not other than the investigator or the lead officer.
Okay, whose responsibility would it have been to question any such persons if they were there?
The officer.
And to be sure, is it fair to say that you are a civilian employee at that time of the Atlanta Police Department?
Yes.
I want to ask you a few questions about follow up on a few questions that were asked of you regarding shell casings. Earlier on cross, you were asked about shell casings being found, if they were found in the vehicle, the blue vehicle, or outside of the blue vehicle. Do you recall those such questions?
Yes.
Does not finding shell casings mean that shots, I need to rephrase. You were asked, do you recall being asked questions by Mr. Adams with respect to the 1007 Hill Street shooting that occurred?
Yes.
And do you recall him asking you about shell casings and if any were found at that time when you responded to that location?
Yes.
And does not finding shell casings mean that shots weren't fired?
Objection, Your Honor, calls for speculation.
I sustain the objection.
Okay. I'll turn your attention to another question that was asked of you on cross by Mr. Adams. You were asked about gunshot kits. Do you recall those questions?
Yes.
And specifically, you were asked about the follow-up with respect to gunshot kits that are processed by yourself. Do you recall that?
Yes.
Let me ask you this. Is it your responsibility after having processed the crime scene to follow up on the results of a gunshot residue kit?
No.
Okay. Whose responsibility might that have been?
The officer or investigator.
Okay. Is it sometimes the case during crime scene investigations that more than one crime scene technician will respond?
Yes.
And do you know a crime scene tech where?
Yes.
Okay. And as it relates to the 1007 Hill Street shooting that occurred, do you know if crime scene tech where responded before you did?
I don't recall.
Okay. Just a few more questions, Your Honor. Earlier, you were asked on cross if you personally interacted with anyone at the 675 Metropolitan Parkway address where the shooting, the second shooting occurred. Do you recall that question?
Yes.
Would it have been your responsibility at that location to interact with any lay witnesses should they have been?
No.
And on cross, you were asked by Mr. Sharp, the attorney for Mr. Stillwell, if when you responded to the 4/12/2015 shooting, he asked you, were all of the photos taken outside or something to that effect? Do you recall that question?
Yes.
Would you have had any reason or basis to go into any home on Fremont Street?
No.
Okay. And why wouldn't you have gone into any home on Fremont Street to take photos?
The officer or investigator wasn't there to tell me that or direct me that.
I'll ask you a better question. Is it fair to say that you didn't go into any homes on Fremont Street because
I stand as to form.
okay, I'll rephrase, Your Honor. Where did the shooting take place that brought you to that resulted in you coming out to the Fremont Street location on April the 12th, 2015?
Repeat that.
Sure thing. To your knowledge, based on your report, where did the shooting occur that resulted in you responding to the Fremont Street on April the 12th, 2015?
1987, Fremont.
Let me me ask you a better question. Does that, when you arrived, did you find, did the evidence that you collected, I'll rephrase, was the shooting inside or outside?
It appeared to be outside.
So a few more questions, Your Honor. Just Just a few more questions for you, Mr. Robertson. When you and I'm turning your attention back to the April 12th, 2015 shooting to which you responded as a crime scene tip. When you arrived to the intersection of the Harper and Brownsville Road streets, was there a white Dodge Nitro anywhere near that scene?
I don't recall.
Do you recall when you arrived to the Harper Brownsville Street intersection, if a Walter Murphy ever came on scene to tell you he was shot at, that he shot at the blue truck?
I don't recall.
Okay. When you arrived to the Harper's Street and Brownsville Road intersection to further your investigation, did a Demise McMullen ever come to tell you that he had shot at the blue car that was there?
I sustain the objections to form. That was Mr. Sharp.
I'll rephrase, Your Honor.
Okay.
Do you recall when you responded to the Harper Street Brownsville Street address, a Demise?
Objection, Your Honor.
Basis.
U.S. Constitution.
Try a little harder. Now. Overruled. Overruled, sir. All
I'll
right.
continue with the question. Do you recall if a Demise McMullen ever came to tell you at the Harper's Street and Brownsville Road address intersection that he had shot at the blue car that you had processed?
Your Honor, no, that would call for hearsay.
I sustain the objections to form.
Did a Demise McMullen ever arrive to the crime scene that you processed at the Harper Street and Brownsville Road intersection?
I don't recall.
Okay. And final couple of questions, Your Honor.
You said that about 5 minutes ago. So come on, let's wrap it up.
Yes, Your Honor. Yes, Your Honor. Did a Rodney Allison or Kevin Treadwell ever show up to the Harper Street and Brownsville Road while you were processing the crime scene?
I don't recall.
All right. And were shell casings found at Harper and Brownsville Road?
Yes.
No further questions, Your Honor.
Mr. Adams?
I was asked a couple questions about who did or didn't show up at the Brownsville location. Let me ask you something. When you got to the location where you saw the car and the blood, was there a Cornelius Davis hanging around to give you a statement about what had happened in that car?
I don't recall.
Okay. What about D'Angelo White? Was there D'Angelo White hanging around to give you a statement about what had happened in that car with his good friend?
I don't recall.
Was there anyone there to deny that they had tried to rob folks in the car and that's how the shooting occurred? Anyone there give you any statement like that?
I don't recall.
Okay. You were asked about a lot of questions about your responsibilities as a crime scene technician. Now, when you show up as a crime scene technician, you're not just a casual observer. You're actually there to collect evidence. Isn't that right?
Yes.
Evidence that can be used in an investigation of a crime. Is that true?
Yes.
All right. So when you were asked a question about whether it's standard to take photographs of property when you arrive at a crime scene, in the Hill Street location, right, the Hill Street incident, where the allegation was that a house, a piece of property, was shot at, does it seem reasonable to you as a crime scene technician that you would want to take photos of this house that was supposedly shot at?
I'm going to object, Your Honor.
I sustain the objection.
Well, But you didn't take any photos of that house, right?
No.
Okay. In regards to the questions that were asked of you about the Fremont location, and whether or not you would go in there to collect evidence, or whether you'd find any evidence in there, how do you know if there's any evidence in a house to collect if you don't even go in the house?
I was directed to this car. This is the location.
And that's it, right?
At the direction of the officer, yes.
Right, and your response to to the prosecutor a little earlier about the responsibility not being yours, about making a determination about this house and if there's evidence in the house, you said that that is the lead officer's responsibility, right?
Yes.
And so, but you don't even remember who the lead officer was that night, do you?
Correct.
But that lead officer would have prepared a report, I presume, right? They normally would,
Correct.
right? They normally would, right?
Correct.
Okay. And that, whoever the lead officer is, although you wouldn't be able to come in here and tell us about why police did or did not go in a location where a car that had been shot was found in front of, the lead officer or detectives or police officers would be in a position to tell us that, right?
I'm gonna object, Your Honor, that calls for speculation.
I sustain the objection.
You were asked, almost done, that about shell casings, the fact that there were no shell casings found in front of the Hill Street location, that doesn't indicate that there wasn't any shooting there. You remember that question?
Yes.
Well, at the Metropolitan Avenue location, where there was alleged that there was a shooting in front of this structure, this property, you actually looked for and found shell casings, right?
Yes.
Confirming what had allegedly occurred. True?
True.
No shell casings in front of Hill Street to confirm, or even defects to the house to confirm the report of a supposed shooting that had taken place there, right?
Objection, speculation, Your Honor.
I sustain the objection.
All right, that's all. Thank you, Judge.
One question, Your Honor.
Hold on. Anybody else? All right, we're gonna find out one question.
One question.
All right?
Ms. Robertson, were there any shell casings found in front of 1987 Fremont Street?
Objection, asked and answered.
Overruled.
I don't recall.
Could you take a look at your report and tell me where it is that the report pertaining to the Fremont shooting?
And I'm looking to see if I found shell casings in front of Fremont.
1987 Fremont.
No.
Is that your answer?
Yes.
Okay. No further questions, Your Honor.
Anything further?
Okay.
All right. May Ms. Robertson be permanently temporary excused as a witness.
Yes, she may be permanently excused, Your Honor.
Madam, thank you for your patience with us. I'm gonna excuse you permanently as a witness. That means you don't need to come back, but just don't discuss your testimony with anybody except the attorneys in this case, okay?
Yes, sir.
All right, thank you, ma'am. All right, call your next witness.
Your Honor, may we approach with a member of the defense, please?
Yes, you may.
Thank you.
in about 10 minutes, and then we'll reconvene. All right, we're in recess. All right, is the state's next witness outside? All right, okay. Are jurors present, sir?
Yes, sir.
Okay. Madam,
Would the court address the matter that we requested consideration for
in terms of what, ma'am?
the next witness image and if the court like to see the witness personally, we ask that the court allow that to be done outside.
All right, Ms. Love, go ahead. Mr. Adams, and I don't think you can be heard. So could you repeat what you said, please?
I ask that the court allow us to allow us the consideration that we requested at the bench before we broke for at least the remainder of today until such time as the court can hear as it wishes from the witness themselves regarding the concern, or until such time that we could just for today.
Why we could, okay, this is again, why we couldn't have taken this up at an earlier time, or you couldn't let me know this so I could go ahead and rule upon it earlier?
Your Honor,
With all due respect to you, madam, and you did ask, okay, but at this point in time, I'm inclined no. I'm inclined not to at this point.
Your Honor, would the court allow it to be heard from the witness?
We should have heard that days ago. Has she been threatened, madam?
As I explained at the bench, and I don't want to say a whole lot, but as I explained at the bench, because of the nature of the work that was done and because of the lack of the protection that carrying the shield would normally provide at this point, we were asking for that consideration that was given to a similar witness in her position who is still afforded the protection of the shield. So we asked for that reason because of the extent of the involvement that she had in particularly sensitive matters that she will go into today and that the court can hear before the court makes a decision about the rest of the week. We were asking for that small consideration for the next 30 minutes or however much time we'll be in here today.
Madam, I am supposed to have a hearing on that. I am. You know that under Rule 22, I'm supposed to have a hearing on that issue.
Your Honor, if there was a media person who was insisting on that, but Your Honor, we've talked things over with the media previously about other matters, and they don't have the objections that counsels for various and sundry defendants are leveling. They don't have those objections. So they are the ones with that ability and with that right with respect to Rule 22. And they have not been leveling those objections.
All right.
So
Anything further
no, we're just asking for that
from
consideration.
the defendants? Anything further? Counsels?
Other than what was talked about at the bench.
Hardening guns of caution, Mr. Matthews. I certainly don't want to put anyone in the particular position of being targeted. And I believe that
This witness.
for this particular witness, I believe that that is a grave concern, given her involvement. So I'm gonna err on the side of caution. Over your objection, I'm gonna allow her to her face not to be shown, but she can be videoed. She can be audioed to that extent. All right?
Thank you, Your Honor.
All right, summon your witness. Oh, hold on, wait 1 second.
Can I do that?
What is it, Mr. Steele? I'm sorry.
Sure. I just wanted to perfect my objection to the Dalbert hearing not being held.
I thought you did that at the bench.
No, we took the break, not we. You.
No, I thought you did that before we took the break,
No.
because you did say about why you objected, and you asked me to have a Daubert hearing. I told you that given the citation I was given, and you cited to me Harris, in terms of your position, It was the court's position, taking a look at United States versus Ware, that the Daubert hearing was not necessarily required, that the state still would have to prove the foundation as to the requirements and admissibility in the court's gatekeeping function. And I'm sure that if they don't prove that, you will ask me to exclude that witness before you have an opportunity, and you'll still have the ability to voir dire that witness.
Can I just simply put this on the record then? Understand?
Yes, absolutely. But I wanted to let you know, that's what I heard at the bench. So what else did you did not tell me?
Okay, so I think you know, we discussed at the bench, it wasn't me, but there's no report that I have from Detective Gates.
Okay, we took up that already as well.
This is what-
Okay, and the report issue was that this witness does not have a report. I know that you've objected in the past that there should be a report. If a report winds up being tendered, I will certainly address that on the spot.
Understood. And under your order of Harris versus State, you put it in written order in this case. You said that the experts have to have a report. That's what the Supreme Court said. It's not mandated by the statute, but it's a better course, and we encourage that for our trial.
Yes, and you have made that abundantly clear through the experts that have testified who did not have a report. So I've noted your objection, sir.
Then that coupled with no CV until today with Detective Gaither. And
You have a CV now.
Then
You had the opportunity. When did you get it?
today,
What time today did you get it?
or last night,
Are you sure that you didn't get it at some time during discovery?
9:04 this morning.
Was it tendered during discovery at any point in time on behalf of the state?
Oh, I'm sorry, I thought you were talking.
State, was it tendered at,
I cannot say with certainty.
tell me what date it was tendered?
I don't know. And that's what we're trying to see. We're looking right now, Your Honor.
Then,
It is a single page, and it is the document that they do have now.
That's not the point.
And I know that I'm looking for what the court has asked me for, and Your Honor, I'm looking at,
it was,
it may have been,
may I make the two more points, Judge?
And
You're
there's-
waiting.
As she's thinking, yes.
I just for clarity. And then we are, as opposed to United States versus Ware, which was cited by the state, we are challenging qualifications and reliability and helpfulness. And the reason I say that is because in Ware itself, this may not be an exact quote, but it's very close. Daubert hearings may be helpful in complicated cases involving multiple experts. Same section.
Multiple experts, but go on. You have to also, multiple scientific experts.
Well, in this case, I have multiple experts, and we're going to have the blending potentially of a fact witness and a witness. You already said we're not doing that. We have to have a demarcation. It's just a lot of information, and I don't know what the expert is going to do that's in addition to and not cumulative of people you've qualified over objection. Detective Dennis, Detective Viverito, or Investigator Viverito, Detective Belknap, who testified, and Detective Underwood. So,
Your Honor,
at some point, to me, you should, respectfully, we should hear, why is it not cumulative? And that's what my objections are. And I appreciate you letting me make the record.
You're welcome, sir. Not a problem. Madam, did you wish to be heard on that last issue of Mr. Steele?
Your Honor, I was just going to say that we've not yet, the jury hasn't heard from anyone except Detective Belknap at this point. And Detective Gaither, we will be clearly demarking and letting the court know at what point we would transition over into anything expert related. My anticipation was today we were not even going to get to that point.
So is the,
Specifically
I'm sorry.
here.
Go ahead.
She is specifically here, in addition to giving her background, what her training and experience is. Of course, she has to introduce herself to the jury. We specifically are here to engage this witness regarding the Dexter Montgomery shooting, that she was one of the ultimate lead investigators on that case, was turned over to the gang unit, and she worked that case. And we are
So is she a fact witness
She is, yes, she
for
will be
Dexter
both.
Montgomery?
Yes, she is in fact a fact witness for Dexter Montgomery. And she will be tendered later on as an expert.
So she's not so at this point in time, she is not,
We will not be eliciting expert testimony from her today. We will not even be tendering her as an expert today.
well, I still need to read the admonition, don't I?
I don't believe so. I think it's at the point where we stop and start getting into the different testimonies. Like when I stop with the fact testimony and get into tendering her, asking the court to have her admitted as an expert. I think the point at which I asked that she be admitted as an expert is the point at which the court rightly give the demarcation admonition, if you will. Because everything that she's going to talk about, at least today, first, will be background and fact. Her background with gangs, just the qualifications, but we will not be tendering her as an expert.
But I correct me if I'm wrong though, but I believe that I did give the admonition before Investigator Belknap testified.
I think Ms. Hilton says that you did, but I'm not certain that I remember the exact circumstances, whether she started with the expert and then went into fact. I think she started with the expert and went into fact. I am going to start with fact, so she's just a regular witness. And until such time that the state asks that she be admitted as an expert, I do not believe it's necessary that the court even broach the subject with the jury. I think.
All right. Okay.
Thank you.
Yes, Mr. Sharp.
I just want to remind the court of one other issue, just in case it comes up. I brought up the issue last week about, or actually on Monday, I believe, about Investigator Robinson and the issue of an internal affairs investigation. And
Yes, I remember that.
ordered the state, and the state indicated that they may very well go into that, and you ordered the state to hand over all files that would be Brady material and hand them over to the defense. We have not received any of those files yet. So I just wanted to bring that to your attention in case the state starts trying to get into some of those things, that we have not received anything as of yet.
That's with,
Investigator Gaither took over this investigation from that individual, I believe.
So, Your Honor, we will
do we have, well, I said independently, have you found or located the internal affairs?
We had to ask for it. We didn't have it. And I believe that we did request and receive some documents
Okay.
that we will be providing to the defense, but we won't be getting to that person at all at any point today either. So
It still needs to be turned over. So Mr. Sharp, if you just remind me again, okay? All right. Anything further?
Just for just to inform the court, the fair court, we have motions outstanding if it's going to be impeachment for Mr. Walter Murphy. The redaction.
I expect that to be done, and you all should probably work that out. I've seen plenty of conversations about it, but you all need to gather your heads about it in terms of whether or not, because I thought my instructions were pretty clear.
we won't be bringing any of that before today is up. So I believe that more.
Now, Ms. Love, I'm gonna tell you, before it comes up, you should have redacted that particular, parts that the court has instructed you. If you have difficulties, then that should be put into writing, and I should be able to decide about that. But I believe I ruled upon all of the Murphy statements.
They added more. That's all it is to it.
You're right, there's some additional.
I saw that
Some
there.
of it's in conflict with what one defense attorney asked. And so the state is confused. So Mr. Shard in his motion asked for a particular portion involving Mr. Murphy to be redacted. Now Mr. Steele is asking for it to be in. We took it out. We already did the proffer. We sent over the redactions as ordered by the court. Mr. Steele, this morning when we talked after he reviewed, had some objections to what has already been redacted. And so we disagree. And so I don't think there's anything except for the court to hear those disagreements, because at this point, we disagree on these additional redactions. But we have done them pursuant to what we've discussed last week, earlier this week. Those are redactions that have been already turned over.
And Your Honor, we don't, like I said, we won't be tendering those if the court will allow us to begin with the witness, and we can, if the court will allow us to further address those matters at the close of the, whenever the court sees fit today. I'd ask that the court allow us to do that outside of the jury being here. Because we have been doing what the court said. But we won't, yeah, there's no need to. We will not be playing the video today of Walter Murphy. And I believe it's a matter that only the court can reconcile. Do this. No. Do this.
When do you think you're gonna get to these, Ms. Love?
Tomorrow, Your Honor. But Your Honor, one portion of the Murphy interview where there was only Detective Dennis, Mr. Hudson and Mr. Murphy in the room. We don't want to put that portion in because Detective Gaither was not in the room. So that part, we can agree to. We've been, I think, pretty accommodating and reasonable as it relates to, as it relates to requests for redaction, where we have facts in those areas where we believe it is perfectly admissible and not in any way prejudicial that the information is being portrayed on the screen. So, if the court, I would like an opportunity to, after court ends today, to briefly address it with the court. I would gladly come in earlier. Of course, the court is aware. I requested that we come in at 8:30 every day and leave at 6:30. I have no problem with that. I would like to get matters addressed before the jury is here. I don't mind how early we need to come in. I will come in at 8, 7:30. But I feel that to have us not able to properly address the concerns that we have with the redactions that have been demanded, puts everyone at a disadvantage when we are notified after we have complied with the court's instructions and after the information was not only served 2 years ago, but 2 weeks ago, there was another notice of precisely the exhibits we intended to use. And the first time we hear about these particular redaction requests is the day we're putting it up. So it's a way that we are hamstrung. We are not allowed to put up our case in a fluid manner. So we would gladly come in as early as we need to and stay as late as we need to hash these issues out. So I ask on the record again, like I did at the bench with Mr. Adams a few weeks ago before Mr. Weinstein ever filed his motion, that we be allowed to stay as late as need be and to come as early as need to address these matters so that our cases aren't impacted negatively by any efforts of people that are different than we are. So I'm asking for that, Your Honor.
I'm gonna dismiss the jury for today. Ingram, summon our jurors, please. All right, thank you, Sergeant Ingram. Ladies and gentlemen, please be seated. All right, members of the jury, it's almost 5 o'clock today, and I think it might be a natural stopping point for you for today. So with your permission and concurrence, I'm going to go ahead and recess you all for the evening. Any minister inquiry of me, ladies and gentlemen? All right, then, ladies and gentlemen, consistent with my earlier directives, what I'm going to do is I'll have you come in tomorrow morning for 8:30 for an anticipated 9 o'clock start time. Tomorrow is an abbreviated day. As one of your members has an appointment, so we're going to recess around 2, okay? To allow that individual to get to that appointment by 3. So that's our goal tomorrow. So I may shorten a little bit of our lunchtime hour or work to accommodate that. We'll just have to see how things go, okay? But that's what I'm going to do with your permission and concurrence, all right? And then Friday, the 19th, we'll gather at 12:30 for an anticipated 1 o'clock start time, and then we'll go to around 5 or thereabouts, okay? All right. Unless you all have anything else, let's go through your admonitions at this point in time. Leave your notepads in the basket. Please don't discuss anything that you have heard thus far in court. Don't discuss it amongst each other. Don't talk about it in onesies and twosies. Don't go home and share it with any of your friends, neighbors, and significant others. Please resist temptation of taking or viewing any third-party sites that cover any other information in regards to this trial. And if anybody should, of course, third party or otherwise, try and approach you in regards to this particular trial in any way, fashion, up close and personal, or through any means of communication or communication device, you need to let myself and Sergeant Ingram know immediately, okay? Remember, don't go by and visit any of the scenes that are depicted or you may have learned about. Certainly don't do any independent research because you can only consider what's been lawfully presented to you within the 4 walls of this courtroom. And remember, you're not to handicap or otherwise recap the testimony of any witness or anything you may have heard thus far, as that would be a violation of your admonitions as well. And you cannot consider this case until it's fully presented to you, and then I give you instructions on how you're to begin your deliberative process, okay? So, and as lastly, as you know, thank you for your patience and patience you've given us up to this point in time, and the patience that you'll continue to give us. So, ladies and gentlemen, unless you have any other inquiry, I'll recess you all for the evening. We'll see you tomorrow morning for 8:30, and we'll get started sometime around between 8:30 and 9 o'clock or thereabouts, okay? All right. We're in recess. All rise. Okay, ladies and gentlemen, please be seated. Chris. Did they include you on Williams' motion number 50? Actions out of court statements. Include you in that? Did they include you on the email? Oh, did you? If not, what I'll do is, if not, I think it'll work. I'm gonna make sure. Come on. I'm gonna include this in this course exhibit in order, so. Okay, let me cover a couple of things before we deal with Mr. Steele's motion limiting number 50, which Ms. Weaver's already been included on, and I will include as the next court exhibit in order the email as well as the motion. Here's the problem, as I keep telling you all, and I'm just trying to say this as artfully as I can, but the challenge that we've been having thus far is that while you all are advocates and think that your position is one that you may be able to introduce evidence, if there is a disagreement, I have to take it up. The problem is that this evidence or information has existed in discovery for the longest period of time. And what irritates the court is that I have to keep stopping. It's not personal irritation or otherwise. It's just that I've told you many times before that this jury in the box, we should present and try and minimize disruptions. This afternoon, this morning, was an exercise in disruption. So if you don't want me to exclude your evidence, then the 4-1 judge is a happy judge, means that you file something or you bring it to my attention way before the witness sits on the stand, and I have to kind of go through edits and edits. So to that point, I mean, I can't make it any clearer. And you all are really trying to work yourselves into working on a weekend, because that's the only way I'm gonna be able to get through this stuff, is that I'm gonna have to excuse this jury and we're gonna work on a weekend to get this done. So be it. If that's what it takes, that's what it takes, but I can't keep stopping in front of the jury and taking up things that you all should have forecasted as a problem. What I mean by that, I'll represent from the state of Georgia. Judge, we're gonna go ahead and introduce his PowerPoint or whatever. We have some concerns. We brought them to the defense's issue, and here's the things that we were not able to work out. Because remember, you all are seasoned advocates. This is not your first trial. It's not like you don't know what you think is gonna be admissible or not. And if you're uncertain about it, that's why you file a motion to limit. The defense has done so on many occasions, but you all drive the kind of the train in this, because if you don't present it, then a lot of times they won't know that there's a problem. Or, as I mentioned earlier, the exhibit changes or you add additional things and they don't have the opportunity to take it up. That's why I'm telling you that it's a problematic issue. So that's what I mean by being forewarned. If you don't talk to your opposing side about this, that's where you're going to run into problems. Because I'm just going to start saying, well, if you haven't talked about it, it hasn't been presented to me, and the jury's sitting in the box, I'm going to exclude it. At this point in time, I am very frustrated, to say the least. And I'm just telling you that being forewarned is more than just 10 minutes before we go out, or coming early or staying late. There are some 30 people that have to get in this particular spot in one time. And I can't blame you all, and I won't blame you all, because the law doesn't prevent me to do that, for not being in the proper place and space you're supposed to. There are a lot of things that happen because all of us have been, and the court is very sensitive, having been a trial advocate going from courthouse to courthouse, parking lot to parking lot. I understand what it takes to get in this courthouse in the morning. But you all have to be here a lot earlier, and you need to be sitting in your places. We need to be waiting on them, shouldn't be waiting on you. There are at least 6 sets of lawyers that have to get here. And you all should not be just sitting down when I get here. If I tell you to be here at a particular time, please be here and be in place so that I can go ahead and start. Because we eat up time that way. And I mean, I just don't know what else to tell you all, but I am trying to be as patient as I can, but I'm at a loss for words at this point in time because I have said this over and over and over again. So if you don't want to see contempt, if you don't want to see us working on the weekends, then please change what you're doing. And Mr. Starr, the inquiry I made this morning is a valid inquiry. None of you would do this if you were in the United States District Court. None of you. My colleagues in federal court would probably jail most of you. And for those of you that have practiced in federal court, this is not the way it goes. From the state's perspective, as well as the defense perspective, everything's filed in advance. So why should you do anything less than in this courtroom? I don't see the same level of professionalism and attentiveness that you all need to do in terms of getting issues fleshed out. It's last minute. That's not fair to anybody. I really want to get it right for everyone. I'm the gatekeeper. I have no interest in case other than see it's fairly tried. But things have got to change. That's why I asked that to Mr. Sharp this morning. It wasn't for any other reason, because some of this stuff I'm just at a loss for. You all are seasoned advocates. It should not make a difference whether or not somebody brought it up or who said what. If you know it's going to be an issue, flag it, present it, and let me deal with it. Or let me carve out a day so I can go ahead and deal with it. I can't deal with this as a witness on the stand. That's not right. So that's why I asked you that this morning. So in the interest of trying to kind of get it right, please just modify your habits in terms of this last minute stuff. All right. Looking at motion in limine number 50, the redaction. All right, Mr. Steele, I have it. I marked it as the next court exhibit in order. So let's talk about it. So in paragraph number 1, you were saying this is the statements for on August 18th by Mr. Murphy?
Correct.
And you're saying it doesn't comply with my prior court order that all statements made by non-witnesses be redacted. So those were supposed to be redacted. All right, there's discussion you indicate regarding unrelated crimes that are not redacted.
That's true too.
So, and then the state redacted the exculpatory Brady evidence that Mr. Copeland, not a co-indictee, killed Mr. Thomas, and this is not speculation if it's co-conspirator hearsay. So let's just break that down. What about the unrelated crimes issue?
Your Honor, there is a conversation about other armed robberies. I'm looking for the exact time that I can point you to. It's on the redacted version that we received this morning from the state. It should be at 11 minutes. It starts at 11 minutes. And again, it's Jacoby Hudson speaking. They talk about sex crimes. And then they talk about who shot somebody in the hip. Going to get life in prison. They carjacked a federal agent. He has so many charges. Jacoby Hudson, the lawyer, asked if they're prosecuting that case.
Okay, so
And to me,
that's from 11 to about 13:56, right?
yeah. That's
Okay. Is the state seeking to introduce any of that?
Your Honor, the state asked the court, here's that information before we make our argument. I asked the court, actually, that's not my microphone. We asked the court, state allowed to play the segment that we have just been.
What's the basis for its admission? Why do I need to hear it? I can read it and say, I can read it and tell you it probably doesn't have anything to do with what we're covering.
Well, Your Honor, the court and counsel are aware, our rules of evidence favor inclusion, and this is not inadmissible. There is nothing inadmissible about these portions that were brought to our attention, or else we would have flagged them. We've actually agreed to take out things that were not permissible.
It's not relevant. It's not relevant. How is somebody about this conversation relevant for anything? What does the carjacking of a federal agent have anything to do with it?
As the court recalls, when we last time excluded a chunk of information and attempted to play portions that became relevant when a witness got on the stand, we were denied the opportunity to do so. That is why we are asking that the court not whole hog grant chunks of information be excluded without hearing the chunks of information and allowing the state the opportunity to point out the portions where we disagree.
We're not going through what we're going through this morning, Ms. Love. I'm sorry. I am sorry. We're not doing that. I excluded that because look, I had made my ruling on that particular issue. So I'm not going back and talking about that.
Your Honor, I have a question for the court, because I think that the state.
I already ruled that we were going to exclude that particular portion. I ruled on it because we had argument on it. So
Yes, sir, yes. So, Your Honor, the state just wants some guidance from the court. And the reason why we're asking this guidance, Your Honor, is we had an administrative order that was filed. And what the state did, especially, and we're going to speak specifically about Dexter Montgomery. On April 4th, as the court instructed, we turned over all of our evidence to defense counsel that we were going to use, everything. That included all these recordings that we're talking about right now, that included what you excluded, the portions that you excluded earlier. We turned that over on April 4th. We received one motion in limine about redactions. That was what Mr. Shard filed on behalf of Mr. Stillwell on April 10th. Then we got another one this morning on April 17th. So what the court asked of the state to do, we did in order to avoid any late arguments. What we understood from the court's administrative order is that state turn over the evidence so that defense counsel can review it. If there are any objections, they would file such. They did that for a portion of it. They never mentioned Mr. White's statement in this motion. They never mentioned any of the other redactions that are coming today.
I got it.
So-
But let me ask you a question. Are those particular portions admissible?
Which portion, for talking about Mr. White or for what we're talking, what Mr.
One we're talking about right now.
We have to go look at the earlier portion. What we have in the earlier portion of this statement, I believe it's the August 18th statement that we're referencing, is that in the room is Mr. Hudson, Investigator Dennis, and Mr. Murphy, and they're talking prior to the interviewing starting. Some things are relevant, some things are not. We need to look at it and decide.
But that's what you should have done already.
But we just got the information, Your Honor. We didn't know.
All right.
So the state believes that it should all come in. So if the defense has an objection,
Okay.
then they have to let us know so we can talk about. And we actually had some conversations this morning before we came to court to see what we can resolve. So we're trying to follow the court's instruction.
I know that, but I want you to go further. I want you to go further in the sense of you need to review your evidence before then and realistically kind of look at this in terms of whether or not it's going to be admissible.
But Your
I
Honor,
mean,
if they
because
never-
it's not like that's what I'm talking to you about.
But Your Honor, they already filed a motion regarding this particular interview, and they didn't flag it, Your Honor. So the state is on notice about what they already.
I understand that,
And
but
they literally list out August 18th, 2015. And then I think even Mr. Harvey had an additional redaction
He
that
did.
we added to it. So we are following clearly what the court has asked. So this is what they objected to. This is what it is. If there was any objections earlier, they would have said that. So we would have then been able to argue it a week ago when we argued this motion. So this is not a new interview. It's not an old, this is the same August 18th, 2015.
it's the same.
interview.
I know, but Mr.
So they never
Mr.
notified us. And Mr. Steele is really good at notifying the state about objections. He did not. And so we didn't think it was an issue
I
until he
understand.
brought it to our attention.
I understand.
And we talked to him about it. We did not agree. And I think that is why Mr. Sharp brought it to the court's attention this morning about Mr. White, because we did try to resolve it. And I think he brought it to the court's attention because we could not resolve it and we wanted the court to make a ruling. And we were trying to find the time the court was going to make the ruling in order for it to happen, because we were following the instructions based on the administrative order. The order said, turn it over. We turned it over. They're going to launch whatever objections we have. If we can agree, we agree. If we can't, we bring it to the court's attention. I think that's what's been
All right.
happening.
So this 11 to 1356. Do you have it queued up at this point?
104.
I understand what you're saying, Ms. Hilton, that two defense counsels have differing opinions as to what should be redacted or included.
That's a different portion. That's not even this portion right here. That's later on. And we redacted based on this, what now another defense counsel wants in. But again, we were not put on notice so we can have that argument and hash that out. So we're trying to follow the court's instruction. We want to move this case along and we're not trying to prolong it, but there are going to be times where the state and the defense are going to disagree. And we just want to make sure that we are properly following the court's instruction. And that's what we want to make sure. And so we just want guidance from the court.
Try not, okay, I understand, Ms. Hilton. Just try not to do that like hours before I need to come, because that should not be, what I'm feeling right now, that's more the rule than the exception. And I don't want to do, and the court doesn't want to do that anymore.
What I'm asking, if we disagree, if we talk about it and we disagree, should we then notify the court that we've discussed it and we still disagree and we think there needs to be a motion? I mean, we need to have a hearing, excuse me. So I just want to make sure that the court, before coming into court, is fully aware. We've talked about it, we disagree, we may need a hearing so that the court is aware. So I just want to make sure we're following.
The earlier the better, because then I decide whether or not the jury comes in that morning, how long we need to do it. Do we need to work the weekend? What time do we need to come and deal with it? But the more in advance I get a chance to look at it, like I said.
And I believe that Ms. Love.
But this is not the way to do it. This is not to do it.
And I think we tried to make calls earlier this week to the defense counsel. Those calls may not have been returned, but I know that Mr. Sharp was dealing with some things as well. So there could be a variety of reasons why the calls were not returned, but we were making calls as well to get this resolved in advance. So we want the court to be fully aware. We're not trying to wait till the last minute. Trust me, we are not trying to delay anymore. We want to get this case moving along, but we want to make sure that we're following the court's instructions and not having evidence excluded after following the court's instructions.
Do you have it flagged, madam?
We're pulling it up. It has to play an evidence reviewer, Your Honor.
Mr. Steele?
Okay.
Just want, everybody should always be nothing but honest with each other in every dealing and professional. And I think that members of the state have done that and will continue to do that. And I know that the defense is trying to do that all the time. But I do want to raise one thing. This when I received this today, the redaction today, that's what I filed, motion limiting number 50. You already ruled on motion limiting number 47, which I filed on 4/9/24. And I specifically wrote in paragraph 2 that the state has indicated it will potentially use interviews and proffers of Mr. Walter Murphy, which is what we're talking about, as exhibits at trial in the above referenced case. Then I wrote, Mr. Williams respectfully requests that, I wrote, without Attorney Hudson, becoming a witness in this case, Mr. Williams respectfully requests that these portions and any other similar portions where non-testifying third parties make statements on the recording be redacted. This includes, I also wrote, any jail calls. The admission of any non-testifying third party at a proper setting, meetings with the police, violates Mr. Williams' constitutional rights and Confrontation Clause, as well as inadmissible hearsay declaration. You granted the state today, and I'm not casting aspersions. When they gave the redaction, I was surprised because all this had happened there, except for the Brady and except for the Mr. Copeland shot, God forbid, shot the man. It's Mr. Hudson. You've already ruled it out. So for the state to say, and I'm not saying they're saying it wrong, maybe they forgot you ruled, but those are all the issues. Mr. Hudson and Detective Dennis, I know you haven't seen it. I guess they're friendly. They get into a major discussion throughout this interview. That's what I flagged. So I wasted my time today to do what you already ordered because you want to have it in writing, and I'm trying.
I understand it, and
that's it, and that's all that there is. So for the state to say they got it today, or there's conflicting, it's not conflicting. Mr. Sharp, Mr. Harvey had issues. I had these.
yeah, I did rule upon that earlier, state. So I mean, in terms of the statements involving Mr. Hudson. So
Your Honor, I think the court should, I'd ask that the court respectfully look back. We carefully, Ms. Hilton was here that day. I was not, I believe. And Your Honor, the court, Ms. Hilton took diligent notes about what was to be excluded. I believe that the resolution to what we disagree on would be sought in what the court said on the record. We took out the portions that the court ordered that we take out. Respectfully, Your Honor, I'm certain that there are areas where people can disagree, but I do know that we have been working very diligently to get those redactions done at her urging, as she was the one here listening to the court. So I'm not certain if there was a miscommunication, if one lawyer heard one thing and another heard something different. Perhaps the answer lies in the record itself, but we took out the portions we were ordered to take out. And as it relates to other matters, Judge, we do not have an agreement. We cannot agree on what we firmly, the court said that we should recognize things that might be a problem. We did, and we don't disagree on those. But the portions that are absolutely not impermissible, Your Honor, and that are only brought to us as a problem, the night before the witnesses to take the stand, we cannot read minds. They're entitled to argue about anything, but we have tried, and many times more Ms. Hilton than I, but we have seriously tried to be extremely accommodating and to anticipate problems. But when we firmly disagree as to whether or not certain portions are permissible, not permissible, relevant, not relevant, that's the place where we have to come to Your Honor. And respectfully, Your Honor, that's what happened today. We were blindsided, and with the way that if the defense counsel is allowed simply to make an objection, and we didn't come up with whatever thing they found in some way could be possibly in another universe inadmissible, then the court has told the state that this court will exclude the state's evidence because they came up at 9:46 p.m. the night before after having this stuff for 2 weeks. And after hearing cross-examination of D'Angelo White, Your Honor, where Mr. Atkins specifically confronted Mr. White with the very statements they are now asking not to be included. The very statements. He literally verbatim asked Mr. White, over no objection for either of the defense, these exact statements. And now they want to keep them out because then it looks like he was arguing something or assuming facts not in evidence, when in fact, he was simply confronting the witness with a prior inconsistent statement, as he was supposed to do. So at 9:46, we get a motion in limine to exclude it, and they've had this for 2 weeks knowing we were going to do exactly that. After Mr. White took the stand, they knew we were going to do exactly this. So we literally have been talking to them. I've called and said, talk to me, call me. Here, I've been told on the record, we don't want to talk to her. Literally, that's what was said on the record. We don't need to talk to her. And so, Your Honor, I'm begging the court not to hamstring the state and leave it in the.
I'm not trying to hamstring you, madam, but I want you all to be prepared. It's ridiculous.
And we have been, and we literally told them last night, we are sending over this final
But I am-
redaction.
But I do
And
not.
then we get this whole list of things. I mean, it's disruptive. You know, we get it at 9:46 at night. And it's not fair to anybody, frankly. The defense, the state, the jurors, the court. It's not fair to anybody.
Well, stop doing it then. I mean, that's the
But,
problem.
Your Honor, we
That's the
can't
thing.
do
Stop doing it.
And we have anticipated a lot, but the things to
And,
anticipate,
well,
Your Honor, not,
madam, I'm
yes, Your Honor.
kind of just, I'm tired, okay? I
So we
really
have
am.
it pulled up.
I really am. Mr. Sharp,
I'm gonna try not to belittle the point, but we at this point, we have filed motions, and I have been filing motions the day before, and Your Honor has said certain things to me, and I accept that, and I'm not complaining to the court. But the things that I have filed in those motions are legal arguments that I never thought I would have to make because I did not think the state would ever try to admit such evidence. Because we have all gone to law school, we all know what hearsay is, we all know what inadmissible evidence is, we all know what irrelevant evidence is, we all know that we wouldn't play recordings that talk about unrelated crimes, wholly unrelated crimes. We all know that we wouldn't play recordings where people say what other people said. So that's, respectfully, Your Honor, and maybe I haven't articulated, that's why I haven't filed these motions. But when I see the state put in their anticipated evidence coming forward through Investigator Dennis, a PowerPoint presentation that is just full of hearsay and full of incomplete, irrelevant, extraneous information, then I actually was put on notice at that time. I said, the state really thinks there's no rules to this. So I really need to start flagging everything. I was not trying to be disrespectful to the court by waiting to the last minute. I didn't think it was necessary to say, I want the state to follow the rules of evidence in the presentation of this case. I am now on notice, and I will be flagging everything I can think of and try to have a happy judge, because you will be a forewarned judge. But I want you to understand that that's where I'm coming from.
I understand.
And so a lot of these things, I just didn't think we'd need to argue about.
All right. Let me hear the statement, the audio from 11 to 13:56.
Hey, old school here. What's up? Now, that was my favorite investigator when we was at prosecuting. We was knocking back. I heard you in the homicide now. You were on Seaway. 6 crimes.
I know me. I think you said 100 and how many?
You talking about David? You know David?
I'm glad they right it on me, bro.
Yeah. How many days did it on?
Full the officer.
Yeah, because you want to know what? Because he's going to be the full what?
Dave, let me black skin, tall skin.
Nah, Dave, he brown. He about to tell the place. He ain't like the one with my phone. Yeah, I'm talking about keep this like this. In my school.
Yeah, you got the oldest guy. You smart, son. You slim, skinny, tall.
Yeah, you got shot in the hip, not a homo. Yeah.
That's exactly what they said. She wasn't doing.
She gonna get my life. They called Jack the Federal. Yeah, I heard that.
Bro, But you do have 100 and something charges, bro.
Murder, 3 home invasion.
I'm saying, babe.
Fine, leave on that. Yeah, okay.
So they was just,
You got a card?
so they was just, when you just working on every day doing shit, basically. So you get out in one day?
No. Appreciate it. They was playing grand with their father in real life. They were. Oh, they don't care.
See, I mean, he shot, bro. He shot.
Appreciate you, my guy.
No, you got a little one going.
Well, honestly, they got over, they went over for, like, they was not thinking it was serious, I guess.
Gabe ain't prosecuting that, though, is he? Is he prosecuting?
Probably serious.
Who was Gabe?
The head game
The head is game. He damn sure likes
He didn't play games.
You heard me? I told him, like, oh, damn, what they say. Hey, them folks ain't really. Shit, the real you know, with me, Gabe, and Lance, you old school. You know what's happening.
That's what I was.
Y'all want to
see, I did.
Yeah, Lance Cross. Knew that folk ain't got no goddamn trying to
Everybody.
Scott Street,
You wanna know what? Cause everybody
leave.
Everybody on what you on.
But shit,
Like,
and then we were trying to, like, this, I don't know if you ever met AJ and Mike, but I'm like, Mike was cool as hell, man.
I know Mike.
Only give us no chance. Man, they don't want to move up. Like, the real thing, he don't really want, like, I was still doing, like, petty drug cases. They'll be in the unit. Yeah, but then, Gabe was, like, having me doing the, you know, I did a lot of pre-lives, I was signing off on pen race, everything. Shit, I spoke the language. Hey, you want to ask someone good again that other thing? Talking about what we talked about? Yeah. I told you, you need to think about Blake. So if that means that you can see your son, you need to talk to them folks. All right? I told you I'm here. All right? So. Yeah, I just got him right up in that club. I don't know if you got it.
Everything.
I think you got it. I think it's 2 niggas got shot. And it's the club high.
Just hang on. Hang on. Girl, I told you. We'll get that person in here who handles the case.
Question though, these folks don't get the chance to see that though. Don't y'all just keep this right?
Yeah.
Like, I don't want nobody, like, no defense, like, seeing that, you know, that Wall Smurf out here telling, you know, then I ain't gonna,
This is like this. And this, on the record, off the record. I grew up in the streets. She grew up in the streets.
She from South Side of Chicago.
I'm from the west side of the neighborhood. I know
Same thing, it's same city.
I know how the street go. We not the ones that will put your business out there. It's y'all pillow talking with people in the cell with you, your girl, the one cat that you think is your homie. Y'all tell that. You wanna know what happened? When you come in, no. Listen. He making a good ass because once y'all get on the phone or once you will put your business out.
And so, Your Honor, up until the point.
What time did it stop?
This is not the point that we were talking about. We played it beyond the point that.
I know that. So what, you started at 1100. Where'd you play till? I think you played till almost 1600, something like that.
We played till 6. It looks to be 1607.
Okay.
And Judge, the point up to where you hear Mr. Your Honor, to the court indulgence for 1 moment.
Yes, ma'am.
Your Honor,
Hmm?
I apologize to the court if the court was in my name.
Yes, ma'am.
sincerely, but this media player is not affording the opportunity to properly play this, so I'm playing it like it's supposed to be played in media reviewer and evidence reviewer. And I sincerely apologize to the court for taking up more time than I should be.
Don't get over this. That's what I'll be looking for, bro. Oh, well, you know what? Come on, Dennis. Y'all already know the truth. Y'all don't understand it. He know that. Well, I just like, if you gonna tell it, then you got to tell it. I just want to protect him. Like, okay, like, y'all look out for him. Like, y'all need to be doing decade behind ball. If he's gonna tell y'all, but we, you know, also we don't have all we can do is make a recommendation. Y'all let, I've already called Gabe. I was just telling him in the lot. You know, that's still like a big brother. I was still in the unit with it when I was prosecuting. What he said it's good. He said it's good. And so, but I told him that y'all can't like grant him no immunity and never like y'all just make the recommendation. Let him know what he said. Right. Okay. That's why a lot of guys think soon as they talk to us, he know that though. Like we got a line where we be like, give him a bond. Right. He know that don't work like that, bro. And he prepared to sit on things that DK know now that shit got real, cause now, you know, one thing for him to have two girls, but when he finally seen that his son and his son look just like he told him change your ways, but I don't know if he's capable of doing that, to be honest, cause he got to change the environment.
Is this 11?
So, we're gonna talk.
What is this section you're playing me now? Because I wanted to hear 11 through 1356, and I heard it already, even though.
2 South 47.
What was it you were going to tell? Because I heard that. I've heard through 1607.
Okay.
That's what you told me.
So the part that we were saying we had no problem to the point, and we were not about to timestamp, where he said, I told you, Mr. Hudson, imploring Mr. Murphy to think about his son. And that if that means he can see his son and talk to the folks, all right? So when Mr. Hudson is encouraging Mr. Murphy to be candid, that portion, up until that portion, we have no problem with. But given the cross-examination and the questions that have been asked and the answers that were given on the stand, we believe it is very important that the jury hears, because Mr. Murphy said many times, as the court's aware, he would have done anything. Well, the jury should hear what Mr. Murphy heard and how, what his reaction was, because that's what we're asking for it to be admitted for, what the effect of the words of the people around him had on Mr. Murphy, because the argument has been made already and will be made throughout this case. Mr. Sharp's whole opening was about Blue Dunham something or another, Fulton County. And so the argument is being made that people are attempting to lie their way out of having to spend more time in jail. When you have a piece of evidence where a person whom a witness trusts is not threatening him, and no one in the room is threatening him, but he is being provided a nurturing kind of environment and being encouraged to just be honest and think about his children, the state believes that it is a very important part of this witness's prior inconsistent statement that the jury should hear. The jury should hear the effect of Mr. Hudson's words on his client. At that moment, we have both detectives in the room. It's not a hearsay issue. We're not offering Mr. Hudson's statement for the truth of the matter asserted. We're offering them for their effect on Mr. Murphy, who has now come in and said something way different than what he said during his interviews. So, Your Honor, up until this point right here, up until the point where he says where Mr. Hudson tells Mr. Murphy, you need to think about Blake, the state has no problem with, because it doesn't deal with him and this negotiation that he is engaging in. They're just having small talk. We are perfectly amenable to taking out up until that point, and we will get that correct timestamp for the court and make certain that we have that to the court. I don't want to play it again because everyone is tired, but I would like for the court to at least understand that we are not asking to include everything that they want out. we are just saying that relevant portions, and of course, number one, our relevancy is low. Number two, we're not trying to get in hearsay. This is things that were told.
Okay, but what is it? Okay, assuming Mr. Steele's time hacks are correct, at 1100 hours, 1100, somebody stops by and says hello. Hudson knows and speaks about sex crimes till about 11:15, about first 15 seconds, all right? So what does that have anything to do with this case?
If that's at the very beginning, I don't mind that being out, but we can't. The problem with giving a generalized description of something that's being said is that we could end up having excluded important parts that we don't agree to and that are relevant and not inadmissible. So that's why we are asking the court not to rely on generalized description of a segment of a witness's interview.
Do you have a transcript of this particular hearing? I mean, not
Yes,
hearing.
we haven't
Yeah.
had time to check it, but we do have a transcript and we're looking at it and we can provide it to everybody in the court to make things easier. We're sending it out now. We have not had an opportunity to make sure that it's an accurate reflection of all that is said, but we will send it anyway.
Let me ask y'all, well, that needs to be corrected, but,
So,
well,
of course, it's that.
well, here's the challenge. Challenge is that you need to, or it seems like you need to have a transcription of the tape so you can kind of figure out, well, what was said so that you can get the exact time marks. So, an agreement.
We agree with that. We had,
And you don't have that. And that hasn't been sent out.
we have it now. There were issues. We ordered it months ago. We were frozen out. So,
Can we take up some other witnesses or hear some other testimony while that is being done?
well, it's already been done. What do you mean, the transcript? Which city?
Yes, because the transcript, I mean, because it seems like to me, I'm not gonna be able to kind of rule upon this until you all have the exact time or what is said, so you all can, say, okay, listen, we want to chop out from here to here, we agree, here to here, we don't. Here, and I can kind of look at it from that perspective.
Your Honor, if I may request something on the court, since we have had an opportunity to check it for corrections, but since we have a transcript that we can provide to the court and to counsel for the defendants, will the court require the parties to identify the portions, the segments, with the appropriate times that they come up, the specific lines in this 161-page transcript that they are asking to be taken out. Since they have already time-backed it, they should be easily able to find the portions in the transcript, even if the words are not always exactly correct, and at least give the state, some hours, so at least by 10 o'clock tonight, provide to us what specific portions they're wanting.
My suggestion is you take that transcript and then the two of you, both sides sit in here and you figure out exactly what you want to line out and what needs to be, what I need to rule upon. Because it sounds like you probably have some things that would probably be not in disagreement. There'll be a limited universe of stuff I gotta kind of consider, but this is not fruitful. This is not a fruitful exercise. It's just not.
So, Your Honor, what we can do, we'll do exactly as the court directs.
Well, that's my suggestion. I mean, because
when we're asking that the court allow us to report a little bit earlier than the court had originally planned, so that if we don't hash it out right now, we can have the court make that decision before the jury even ever gets in the building. And Your Honor, what I can do is, for the sake of moving things along, I can play portions beyond, anything that we can't agree on. I can, play portions of it with the understanding that after the court makes a decision, we are either going to be allowed to go back and play that portion, or we'll just keep moving on without it. But this is something that can be dealt with between now and the time that our first witness is to report tomorrow. This is one interview that will not stop the show. We can do what we need to do, and we can stay and we can go over this and we can report as early as the court asks us to. And we can send a report of our ability to work through it to the court this evening. So the court is on notice as to what we were able to agree on and not. And we may even come up with a solution that's acceptable for everybody. I don't know, but we're willing to stay until it's done.
Mr. Sharp, I saw you rise.
Your Honor, two things. We have already identified those portions, but the other larger issue that
I don't think you've identified them with they don't match. I mean, because theoretically, what you have and what Mr. Steele has and what the state has should all be in the same. Like the first one I heard, I didn't hear all the words. The second one I heard all the words.
But the larger issue, Your Honor, and I'm just speaking from my experience. Generally, when we've been dealing with prior inconsistent statements, in my experience, it hasn't been someone said something that the state feels is inconsistent, so they just put in a tape. It's focused. If Walter Murphy said the sky was blue, and Stan said it was red, but he said it was blue to Investigator Gaither. Investigator Gaither, when you spoke to Walter Murphy on January 1st, 2023, didn't he say the sky was blue? And then that's how they get in the prior inconsistent statement. I don't really understand why we're playing just these lengthy tapes to impeach people, because it's not focused on the inconsistent statements. And that's why we're getting in Jacoby Hudson giving, friend talk between Jacoby Hudson and Investigator Dennis and all these other extraneous things, because we're not focusing on the discrepancies. And to me, that's what prior inconsistency.
Okay, that's one thing, but the state says that the effect on listeners. So what's your take on that?
That is irrelevant. That is not proper to be playing tapes of Jacoby Hudson, who's a witness in this case,
But he's
speaking.
not a witness. He's not.
Yeah, he's not a witness. That's what I'm saying. He's not a witness. And so I don't know why we would be playing tapes of him talking to anyone.
For context, Your Honor. And we also.
Well, I understand that the state wants to, but
I agree, but his lawyer's statements, Mr. Hudson's statements aren't relevant. They're not.
Your Honor, I have encouraged, because this is how this has gone so far. What the questions have been to these uncooperative witnesses have been, did they tell you that you could get out of jail? Did they tell you this? So somehow or another, it's okay that they make an issue out of what the prosecution said, and then we're allowed to meet that with what was told by his attorney in the presence of others. So it's not protected or privileged. It is absolutely relevant, Your Honor. It's not, relevance is obvious.
I get that, but but it's very defined and targeted. Him talking, Mr. Hudson talking about, the sex crimes or shooting or whoever. That's not relevant. That's not relevant.
What we've been saying, and the court said exactly right. There are portions that we actually don't have a problem with excluding. We agree with the ground, okay, we'll take that out. But the portions, and that's why we need to go over, because the portions that we believe should not come out are the portions like that, where as opposed to, as the defense has intimated throughout this trial, people are being forced into agreements that they don't like. And the words of the prosecutors are somehow being made at issue. When a person is being encouraged to be honest, and they have every motivation to, Mr. Murphy got up here in front of this jury and he just, decided he was going to imply that he lied all the way throughout all of his interviews. it is very important that the jury understand what circumstances Mr. Murphy made these statements under, and who was doing what, if he was being threatened with jail time unless he talked, because that's the image that they're getting. And they are asking the court to exclude the state's relevant portions of these interviews with Mr. Murphy and the detectives in this case with his trusted friend. If the court remembers, on cross, Mr. Murphy was asked about his relationship with his lawyer. And on cross, he was asked about whether or not Mr. Hudson paid his bond. So if they're going to be able to bring up things like whether Mr. Hudson paid his bond and how close Mr. Hudson was to Mr. Murphy, then the state should be allowed to introduce portions where Mr. Hudson is encouraging Mr. Murphy to just be honest. And he is.
I don't have an issue with that specific, but these other conversations are them talking about other crimes, about improper statements about other people.
Those are recorded. That's fine.
But they need to be excised. They're not relevant. They're not relevant.
Problem is that we agreed to take out everything up to that point. That's what we're saying. This is not something that's, this isn't even a hard one. We agreed to think about like, and if there are portions after that they feel strongly about and they want us to reconsider and look at, then allow us the opportunity to do that. But they're not wanting to do that. They're trying to argue the issue about whether or not the recording is even permissibly played before the jury. And that's just an effort to try and get the court, I guess, to wear the court down and have it all taken out. Your Honor, we're just trying to get it in. We're trying to talk. I've been doing it all along. We're not going to stop. We're trying to come to some agreement as to what can be done.
All right,
But we can't agree on.
Mr. Adams.
Let me just say this. Along the lines of wearing the court down and trying to confuse the court, let's be absolutely clear about one point that Ms. Love is talking about. That she doesn't appear to really know, is that it was Ms. Hilton who asked the witness about his relationship with Jacoby Hudson. It was Ms. Hilton who asked whether or not did he pay your bond. Now, nothing in what Mr. Murphy said. He never said, I said what I said, or I did what I did, or I gave this statement because of something that Jacoby Hudson said to me. So just because they want to try and infer that was part of it, doesn't mean their strategy becomes evidence. There's nothing relevant about what Mr. Hudson is saying to Mr. Murphy. It doesn't become relevant simply because they want to use it. And if Mr. Murphy in his testimony had said, you know what, I would have done anything to get out of jail, or what my lawyer said to me, had some effect on me, they could teach him with that. But he never said that. Can I finish, please?
Hold on. Let him finish.
Any question about his relationship with Mr. Hudson and how close they are came not from us. It came from them.
Okay, so Your Honor, he literally said that. I would have chopped off my arm. He said
He did. He said that.
He said it throughout. Every chance we asked him a question, every time we asked him about this interview, and Ms. Hilton confronted him with the statements during the interview. I don't remember what I said, but I was high every day for a whole year, and I would have said anything. I would have said and done anything to get out of there. I would have said and done anything. So throughout his testimony on direct, he kept putting forward that he didn't remember and wasn't truthful and had reasons to not be truthful, and his impetus to not be truthful was he wanted to get out of jail. The one thing that is true and obvious from this recording is that the only thing he was asked to do was to be truthful, even by his trusted friend. He was asked to be truthful. That's it. So if he had any.
Okay, but that's only a couple of statements from Mr. Hudson, which I agree with Mr. Adams may be marginally relevant in terms of what was said, but I think that he's already been kind of examined on that issue. So.
But he never told the truth about it. He continued to be untruthful.
But that's what the jury's going to decide. The jury is going to decide that particular issue. But I'm telling you, you get into more problems offering this particular state. You just do.
And Your Honor, we have to give them the prior inconsistent statements. We're going to make this decision. Otherwise, all they heard is him saying, I don't remember. And I would have told anything to cut off.
Okay, but I understand that, and that's a disagreement, but that you and Mr. Adams have and Ms. Hilton has, but all this other stuff, not relevant. It's not. The conversations with Mr. Hudson are not relevant. They're not. So I mean, and this transcript's 100, I mean,
The portions that they're asking to be taken out, I believe, in on page,
what page?
I believe it ends on page 30, I think. I'll have to listen to the general time to be sure, but I think
To
it's just on
page 30 of 161, the interview of Walter Murphy?
Yes, I think that.
The 18th, the August 18th, 2015 interview?
Yes, I think that that's what they're asking for, up to, the point where investigator says where, so I think the last part where conversation is taking place is Mr. Hudson saying, I got referred to him because his mom and his grandma went to the church praying folks, and I've been mentoring kids there for about 2 years trying to get them right. But I can't keep them away from you all. And then Investigator Gators tells Mr. Murphy, you're gonna have to make some changes. And then Mr. Murphy says to Investigator Gators, this is the part where.
Well, what page are you talking about?
Page 30, John.
30 of 161?
Yes, John. I can show it to you. It would be line 4. That is the part where we would want to start. We would have no objection to cutting out page 1 through 29, and then up to line 3 of page 30. So that even includes the portion about Blake. So Judge, that's the portion, I mean, that. Notwithstanding that I feel that portion is important, that the jury should be allowed to hear it because it's relevant.
Yeah, I mean, especially, I'm looking at page 30, 161 counsels. I'll include as the next court exhibit in order the August 18th, 2015 interview. Are you under the influence of any drugs, alcohol, medications, or anything like that? Mr. Murphy, no. So yeah, that would be admissible because he testified, I was high. So,
Right.
okay, all right.
And even at line 13, where he says, all right, I'm not gonna lie.
Yeah, I got it.
Your Honor,
Yes,
may I ask which transcript are we looking at?
August the 18th, 2015,
You
it-
said page 30?
30 of 161.
The state just sent us something.
There's
Oh,
3.
Now it's popular.
Yeah, it takes a while to populate, but it should be pages 30 of 161 once it's fully paginated. So what they're willing to do is the state is willing to take out 1 through 20, pages 1 through 29, up through line 3 of page 30, and start at line 4. I advise the rights. Councils, my suggestion would be you go through the transcripts. flag the exact language that you are, that you can agree upon, and, or actually flag the statements that you are in opposition, that you can't reach agreement. I can rule upon those, but it doesn't sound like that would be the best way that I think the court could probably.
The court has ordered us to take out are out.
They're gone.
For the purposes of this hearing, they're out. And now we are at the point where they have asked that a time frame be omitted, and we are agreeing to omit the whole first 29 pages up to line 3 on page 30. That, along with whatever the court has previously ordered that we have out, will be out. Anything else, I just ask that the court have them to let us know by 10 o'clock, because we can have, if there are other things that we can agree to or something else that they are in opposition to, at least that gives us time to perhaps even agree and make the change. But when people are aware that we're doing that, redacting things, it would really help if we could just have all of the precise areas before the multiple redactions are being done. So,
Your Honor,
anything that we can't agree on, I'll ask the court just
Yeah, it looks like, hold on, Mr. Sharp. Mr. Steele, it seems like that, and Mr. Sharp, it seems like you all probably need to kind of refocus what you believe should be in or out. I think you all maybe will do that by agreement.
Your Honor, just humbly, I don't understand if, for instance, if this tape is being played for the fact that Walter Murphy said, I was high during these interviews, and he was asked during the interview, are you on drugs? And he said no. Why, instead of playing a tape, doesn't the state just ask Investigator Gaither, when you spoke to when you spoke to Walter Murphy on August 18, 2015, did you ask him if he was on drugs? Yes, I did. And what was his answer? He said he wasn't on drugs. That is impeachment by prior inconsistent statement. There it is right there. I don't understand respectfully why we're putting in a videotape to impeach by prior inconsistent statement.
I can tell Your Honor why. Because the videotape shows his demeanor, shows the circumstances, the environment under which he made that prior statement, and the context in which he made that prior statement.
It
So
does.
having.
It does, Mr. Sharp. So it does.
Well,
it does, but I would concur that some of this stuff here is not, that's in this tape, is in the interview on the 18th is not relevant. It's just not.
And we don't have a problem taking it out. But when he sat there on that stand and said he doesn't remember anything he said,
Yeah, but
and even after he.
That's one thing. That's one thing.
We're in agreement. We're okay with whatever. We know, like I said, those first 30 pages, and there are other areas that they're just
So if I
adamant
understand,
about. I don't have, looking at that and trying to come to some understanding with counsel for the defense. That is what the court has ordered that we do. I thought we were at the point that that's what we were gonna do, but if we're not, and further argument is needed, I'll let counsel make their arguments, but Your Honor, I'm asking to have, if there are areas that they want redacted, now that they have a whole transcript, just tell us the lines so we can know if we agree or disagree, and at least we can tell them why we disagree. And we can have a very targeted argument before the court, as opposed to telling the court, generally speaking, what's being said.
Okay, I'm gonna tell you that most of the statements with Mr. Hudson should probably be excluded, other than the ones that he's talking about his client and telling him to tell the truth and advise him of his rights. Because that does go contrary to what he's testified to.
And there are areas where Mr. Hudson asks someone to clarify a question so that Mr. Murphy can fully understand and answer it as accurately as he could. When Mr. Hudson is
Well,
lending
that would
assistance.
I mean, that would go to show, because he said he was high.
Right,
So,
right.
yeah, so yes, that would,
So,
but the other relationship to other uncharged crimes or whatever else, and else is not really admissible.
that's fine, we can do that.
All right. I'm sorry, Mr. Short, I apologize.
Your Honor, as the person who controls the courtroom and the way the evidence is presented, I'm just trying to understand, do we anticipate the state would be asking a question? Investigator Gaither, didn't Walter Murphy tell you this on that date?
No.
And then, Mr. Kokomo, would you play at 4 minutes, 30 seconds? Hold on, Ms. Love. Would you play at 4 minutes and 30 seconds and then the 10-second clip plays?
No.
And then we move on to another subject?
No.
Or are we, Ms. Love, I'm asking the judge a question, okay?
Yeah, he is. So,
Or are we anticipating just having the state say, Investigator Gaither, did you talk about the Murphy on August 18, 2015? Yes, I did. Do you recognize this CD? Yes, that's the recording. And then they just plop it in and play everything. Because I just don't think that's appropriate impeachment by prior inconsistent statement. It needs to be targeted point by point
I
by
agree.
point.
I agree.
And we did. And Your Honor, that's the whole reason we took such painstaking time to confront Mr. Murphy with these different statements. We did the same thing, and that with other witnesses, we have to go through each line by line. We have to go through it and confront him specifically with specific portions. And then they argued about that. They argued that
Well,
him
the
saying
challenge
he
in this,
forgot was enough.
well, the challenge in this is that I think that you do, there's enough, that Mr. Murphy's testified enough that there are a lot of things he's probably going to be, or some things he'll be impeached as to.
He's gonna get impeached as to everything. And Your Honor,
Well, but I'm just telling you that I agree with Mr. Sharp. You just can't play tape. You're going to have to break those down individually into the areas that you believe that that you're seeking to impeach him on. For example, his recollection of events or whatever, since he was high, well, then certainly playing those particular parts of the tape that would show that he had presence of mind to understand certain things and to clarify certain things, yeah, that'd probably be relevant, but not everything. I mean, it just depends upon what you're trying to impeach him on. So I do agree with Mr. Short. You've got to kind of be, impeachment's targeted in that respect.
And Your Honor, what we're trying to get at is context is key. And when he is telling them what happened, he sat here, whenever he was on the stand, and said he had no memory of the day. He had no memory of it.
Okay,
And so we can't.
and I don't have any issue with that. I don't have any issue with it. I just don't want you to get into the fact of talking about people that are
His relationship with co-defendants, That's relevant. He
No.
denied a lot. He said
The
that they.
I mean, that's one thing. Co-defense is one thing, but the carjacking of a federal agent,
Take it out.
About
It has nothing to do
Mr.
with it.
Hudson
Take
talking
it out.
about his experience in the DA's
That
office.
definitely will come out.
About
So,
I mean,
Your Honor, what if we
there
just
are a
sent
lot
you
of things
all
that,
the redactions?
there are a lot of things that need to be redacted, or you need to be very clear about what area they take, and that's where I think the transcript will be helpful.
Okay.
You all will need to kind of, I mean, that you'll need to kind of just play these particular certain parts of the tape that you believe are relevant for that inquiry. So
Your Honor, in
So
order
if you're
to.
gonna do that, then I'll rule upon it on an as needed basis.
So, Your Honor, this is what I'm asking. So we will, since we could not get, so we're not going to have the defense identify the areas that they want out. So instead, what we'll do is we'll go through and we'll identify the areas that we believe are in alignment with what the court says should not be in. And we'll identify to the court the areas that we'll take out. And we'll send that to the court, since I don't know what we're gonna get from them. So we'll do everything we can to move it along. And then when we get here in the morning, if they haven't given us anything, maybe the court can assume that that's okay with them, what we sent the court. So we'll send it to the court. They can do whatever they want to do. We'll just be at the court's mercy, and we'll send you what we believe should come out.
Well, just, if they could just say what they believe should come in.
No, Your Honor, we're gonna actually play silent. We'll silence the part, mute out the portions that we identify, because what Mr. Stark wants, I'm sure, is not to have a flowing kind of circumstance where the jury can really evaluate what's going on in that room. He wants us to start and stop, a minute here, a minute there. That's not happening, because, not unless the court makes me, but because that's not fair, and that does not serve the interest of the jury actually seeing the truth of what this circumstance actually involves.
Okay.
I just want them to
All right,
follow
hold
rules of
up.
evidence. That's it.
Hold on. There may be a lot of reasons why jurors listen to certain things. This is just for impeachment. If you're trying to get in for impeachment and it's relevant for that, and you're telling, and you're going to get through Detective Dennis that, yes, this is the interview and here's the issues that you want to bring up, that's fine. I mean,
and of course, Your Honor knows that impeachment evidence is also substantive evidence, prior inconsistent statements.
Yes, it
So-
can be, yes, ma'am.
so-
I mean, so that, if that's the case, I'll take up those on an as needed basis, but I agree with Ms. Sharp, you just can't play the entirety of the tape. I mean,
Well,
there's a lot of stuff in there that's not relevant for any reason.
And we can mute all of that out, Your Honor, and we will identify, just for the ease of this. I think it's a glass half empty, half full kind of situation where he's calling it one thing, I'm calling it another, but we will identify the areas that we will not be playing, and we will mute out those areas and let the jury see the interaction, but
Okay.
mute out the sound
So,
in those areas.
so Mr. Steele, it looks like from your motion that you filed, the state's not going to get into unrelated crimes. So that they've agreed, and I will order that they not. Talk to me a little bit about this, about the Brady, exculpatory Brady, Mr. Copeland.
So according to the prosecution's theory that you allowed in indictee statement that are not testifying, Mr. Walter Murphy is allegedly a co-indictee. He hears from supposedly co-conspirators that Mr. Copeland, potentially an unindicted co-conspirator, is not a co-indictee, who supposedly will testify, killed Mr. Donovan Thomas. The state redacted that, like what I got this morning, the redaction. That's not in there. I don't know why that wouldn't be in there.
Because on number one.
Did you finish? Go ahead and
We're
finish.
only going for impeachment, which is what I say in paragraph 3. I said none of this should come in unless it is a proper impeachment. And I agree that it has to be targeted. Mr. Murphy said that he was on drugs at the time. He was asked, are you under the influence of any drug or alcohol?
No.
No.
So, yeah.
I have no problem.
Yeah.
But hold
on, let me finish.
the state's redaction includes all this other information, then I didn't know how the court would rule. But then all of a sudden, this exculpatory information, because the gentleman is not charged, state's witness, and allegedly he's the killer, that's already out. So I don't think it comes in. What I'm saying is, I just want it to be the way you just said. The state should give us, what do you contest is a prior inconsistent statement. Once they do that, we can then say, Your Honor, I don't believe that is true. You can then make the call, go to your, go to the transfer, however you're going to do it, and say that is a prior inconsistent statement. The state is right, you're wrong. And that's how we do it. That's the only way I've ever learned it. I also don't see why we're playing it. I agree with Mr. Sharp, but if we are playing it, you play that targeted issue, not the entirety to get the balance. So that was my issue. If the whole thing was coming in, I'm like, well, why is that redacted? How did that happen? That's the only reason I put it.
Okay.
I don't believe it ever came up, and I don't believe it should come in. But if other things are coming that were other crimes, I said, why is this coming? That's all the only reason I put it.
Yeah, Ms. Fulton will respond.
Madam.
Your Honor, as it relates specifically to what Mr. Steele just said, the reason why we're asking for the portions of the statement to come in that we're asking for once all the redactions are completed is that is what he was asked on the stand, and that's what he denied. So we confronted him with it. We went through the entire Dexter Montgomery scenario with him. He denied it. He came up with his own version that he did not remember. We intend to play that.
Yeah,
We talked about the Little Wayne Bud shooting.
That's by prior inconsistent statement, yes, but you're gonna have to,
And that is
you're gonna have to chop those out. You're gonna have to, I don't think anybody's saying anything that's not what the law provides. But you are gonna have to kind of break it out. And he's gonna have to, I mean, whoever witness you offer it through, however it's done, is gonna have to be, you're gonna have to kind of confront or basically, it's not, you're not confronting this witness, but you're just kind of, you're oriented to time and place and what was said. And then you're asking a question, well, what did he tell you during that particular period?
We will, I believe we can handle it by asking were these questions propounded to him and did he respond? And then we can play it accordingly through the video without her having to go through the transcript. I think we can ask, were these questions asked to him? Did he respond? And
that's fine. I don't have an issue with that, but I'm just saying, I think that some of the stuff that, like I said, that Mr. Hudson was talking about,
we agree, that's out.
It's not relevant. And the other crimes, stuff is out.
All of that is out. However, I do want to address this Kenneth Copeland issue because this issue that Mr. Steele is saying is exculpatory that the state took out. The state took out any mention about what was heard about the murder of Donovan Thomas by Mr. Murphy pursuant to what was filed by Mr. Shard on behalf of Mr. Steele. That is how it was explained.
Okay.
D&E of his motion specifically talks about what Mr. Murphy heard at the jail about the shooting of Donovan Thomas. So I understand that Mr. Steele is calling exculpatory, but when we had this motion, he did not object to that portion being excluded.
So Mr. Steele, why don't you address that? Because we're kind of, when we're taking it out at Mr. Sharp's insistence. So I guess you're telling us, hey, well, I want it in.
Because the state gave this morning the redaction, they leave in all these other crimes and armed robberies and sex crimes. And why is that? But that's the only reason I left it in. Like I said, I don't find any of this to be admissible. We're talking about impeaching evidence. The witness testified. It is very narrow now.
Yeah, are you gonna, is it your intent to ask investigator, what's her name? I apologize. Gaither about Mr. Copeland?
Well, that gets in, yeah, the answer to your question is yes. But that's why I asked you the other day, I don't remember when, I apologize. Can you ask the state, is she coming back? She's a detective case of female. Is she coming back multiple times? Because I want to do it one time. And I don't have enough information in the record. So I want to do it when she testifies after the Donovan Thomas is litigated. And if the state is not calling her, I was going to ask if you would do what you did for me for Detective Belknap and allow me to call her for cross-examination in my own case.
Hold on, one second.
So Judge, as it relates to, Investigator Gaither, I did try to speak with Mr. Steele, and I'll talk about it now, but we intend to get into with Investigator Gaither, everything that she covered in the interview of Mr. Murphy, that Ms. Hilton asked Mr. Murphy about. Everything that she covered in there, which includes the Little Lane bus shooting, Dexter Montgomery, anything that Ms. Hilton asked him about, that he talked about.
Did he talk about Mr. Copeland
He did.
and Mr. Thomas?
But he didn't talk about them for person. They said, if you had to guess, who would you say did? And then they asked him about the Little Lane bus shooting. If you had to guess, who would you say fired a shot?
That's, I don't want to interrupt you.
And actually, what
Go ahead.
we have the transcript. And so they asked him to speculate about certain things, and he does. And Mr. Sharp has asked that we take out certain speculation about his client, and asked us as well to take out speculation as it relates to who murdered Donovan Thomas. So we took out the speculation.
But, okay, but I think that it's still fertile to ask about,
I don't know.
to ask Mr. Sharp and Mr. Steele about the involvement of Mr. Copeland and purportedly Mr. Thomas. I think that that's admissible to cross Detective Gaither. It's just a question of Mr. Steele. I think that what the state's telling you, if I'm reading them correctly, is or I've listened to them correctly, they're saying that they're going to bring out everything. So that would be appropriate for you to examine her if you choose to do so on Mr. Copeland. Okay.
That's okay. I'm sorry.
I want to be clear for the record. Because of the redaction, we never asked Mr. Copeland, we never asked Mr. Murphy about his speculation as to who he thought shot Donovan Thomas, because that would have brought a speculation objection.
But there's a good faith basis to ask him the underlying issue.
Which would be who killed Donovan Thomas.
Yeah.
But
If he knows.
If he knows, well, yeah, of course.
Yeah.
We would love to hear that answer if he knows.
Yeah. If he knows, I mean,
But what we took out was he was speculating about what he had heard. Because if you can recall, Mr. Murphy was in the hospital when Mr. Donovan Thomas died. So
well,
he had
I mean,
no personal knowledge of it.
yeah, they asked him. I mean, but I mean, that's the examination for either one of you. I mean, but I mean, the form of the question in the video draws speculation. But it doesn't mean, but you have, since it's in there, I would think a good faith basis to ask whether or not, why did you ask whether or not, Mr., were you just fishing or did you know something?
So just to be clear, the state redacted it out of the video. If Mr. Steele wants it, then we can very well play it. What we need to know is which way does it go? It's out right now. The version that they have, it's redacted and it is out.
Well, I think
it's upon the initial motion, but if he wants it in,
here's the thing.
we can play it.
I think you got one advocate that says, I don't want it in. That's Mr. Sharp. You got another advocate that's saying, no, I want to ask him about it. And he's because they have different interests. So I think that.
So the state just needs to know which one to do.
So, yeah, I mean, no, I'm just saying that, I mean, I think that you've excluded thinking that that all defendants are the same opinion. One advocate now said, no, I'm going to go ahead and ask about it. It's relevant. And you're going to have to probably let him go ahead and examine about that issue.
So we will want to play it. That's my question. If he's going to ask, we have no problem playing that portion. And so that's what we want.
But you could play it. You can play it in. I understand what you're saying. You can play it you can play it if that's what you wish to do. But here's the thing. I would say to you.
So Judge, what we're saying is, since someone wants it out, and
another one wants it in.
That's the one that wants it in, please.
Yeah.
Let them deal with it, because we won't withdraw that here.
Yeah, Mr. Steele, I'm gonna let you, when you examine Investigator Gaither, Mr. Shaw will probably object. I'll rule on it at that point in time.
Understood.
But because you all have you may have differing theories of the case or differing things. So I'll rule upon it at that point in time, but I'm going to let you ask about it.
Thank you.
So Mr. Short, that's my ruling on that particular issue, okay?
Can I just clear up one other issue? I know it's late. We are talking about prior inconsistent statements. As I understand, here's the exception.
No, that's Brady. That's
Not that particular issue, just generally Walter Murphy playing for. As I understand it, he is supposed to be confronted with his prior.
He
statement.
being who?
The witness, Walter Murphy, is supposed to be confronted with his prior statement.
He was.
Okay, but here's the thing.
Ad nauseum.
Well, he really wasn't though, because no one played.
We covered this before, Ms. Sharp, with another witness. They did ask him, I mean, in painstaking detail as to these particular
Your Honor, no.
statements.
Your Honor, I'm just going to point out that when someone actually played the statement that he made 8 years ago for him, he testified completely consistent with his statement. When I asked Mr. Kokomo to not say anything to him and said, could you just please play the statement that he made 9 years ago or 8 years ago, and he listened to it and then he testified, he said everything consistent.
Okay, but here's the challenge. He's testified, he don't remember. He was high, okay? And I
He didn't remember.
No, well, he said he didn't remember. He did. So the state's going to be able to challenge him on that. I mean, you can impeach by omission as well, or by inconsistency. There are Georgia law allows about maybe 6 or 7 methods of impeachment. Okay, so I'm just going to tell you, it's. I think that the state's got a good faith basis to impeach him on a number of things. So we'll just disagree on that. I think you brought this up through another witness as well. So I understand your point of view, and I'll certainly respect it, and I'll rule on it accordingly. Okay.
Thank you.
All right. So, Mr. Steele, is there anything else I've not covered in terms of your motion as of yet?
To answer your question directly, no, as far as that statement, but there is a second statement.
That 15 July,
And I don't believe any of that should be played.
and this is, you said should be excluded
I do.
because Mr. Murphy cooperated with the state on 2 occasions, August of 2015 and February of 2016, and it says there's several series of statements, 1215 and 1240, and going through 123 to 56 to 125, and those statements are. Let's just do it this way. Gaither at 1215 to 1240, Gaither talks about being at Thug's house for search since 6 a.m. and someone identifying WM Walter Murphy to her home.
Right.
At the house? All right.
So, this was a search that was excluded. So to me, it's.
Excluded by me earlier?
Yes.
Okay.
This is a July 15, 2015 search, Judge Newkirk.
Ah, yeah,
That's why
this
that's
is,
out.
huh?
That's why that's out. We had no intention of playing that.
Okay,
part.
so-
We purposely excluded that part.
So let me just, for the purpose of the record, 46 to 4715, the search of Mr. Williams' home, 55 to 5610, Dexter Montgomery, alone at hospital.
Those time hacks are not. we
They're
do
not,
agree
okay,
with
but-
those time hacks.
So the search of Mr. Williams' home, the discussion about being at Mr. Williams' home and the search, those are all out?
So no, Mr. Murphy was arrested at Mr. Williams' home. This is what was out. This is the part we took out, where Detective Gaither says we found a shit ton of stuff at Thug's house. All of that has come out because we cannot address the search. But the fact that Mr. Murphy was arrested at the house, the fact that I believe Mr. Arnold, I have to look at it again, was arrested at the house. Those are not.
Okay, let me just kind of walk my way through that. 40, so let's start at around 55 to 5610. Dexter Montgomery alone in the hospital. What about that?
Yes, Your Honor. Let me get that transcript. Hold on.
I can give you a flavor if you want.
So,
Go ahead.
what she's
Hold on, go ahead.
Simply Detective Gaither saying to Mr. Murphy, how much time, what should happen to a person who did this to Mr. Montgomery? He's in the hospital alone. His mother, God forbid, has passed. It's just Detective Gaither saying that. I don't understand how that's.
How would that be
I
relevant?
have it, and I wanted to pull up everything because see, when we do snippets, we get stuff gets lost. So the point of having that played, Your Honor, is that I'm charging. The point of having that played is Walter Murphy was confronted with statements that he made in that July 7th interview when Ms. Hilton, July 15th actually interview, when Ms. Hilton asked him about it. Specifically, what he did, without prompting, he started talking about lamenting over the fact that having been seen with those officers, we're going to get him killed. Now, we have that transcript too, so we'll give that too. She asked him about that a number of ways, and he consistently said, like, I don't know what you're talking about. I was worried about the bloods in jail. That is not what he said in that July.
Is that Mr. Montgomery being on the hospital, or?
No, what she's doing, and that's why I said you can't look at it the way that they presented it to the court, like these little sentences, because what she's doing is encouraging him to tell her what happened. She is telling him what.
Where is this conversation being had?
At the Atlanta Police Department.
Okay, so this is Walter Murphy and Detective Gaither having a conversation?
Yes, this is the day. And in fact, what happens is, this is the best part about that July interview. What happens is Detective Gaither sits down with Walter Murphy
and this is where Detective Gaither's knowledge of the facts, Detective Gaither declares her belief that thus Walter Murphy, Detective Gaither gathers how she conducts her investigation. Detective Gaither declares how Walter Murphy is chasing an image and doing dumb stuff.
Your Honor, that's the summation that you've been given by Mr. Steele. I think that this is the one where Detective Gaither says to Walter Murphy, I don't need you to tell me anything. I have it on video. I have you. You asked to talk to me. I'll talk, but if you don't want to talk, we don't have to talk. I can end now.
So are you, okay, let's parse this out. So are you these statements that are made by by Walter Murphy to Detective Gaither, are they impeachment in nature? Okay, all right.
Yes.
I'll take up those as I need to, but because they would be relevant if you can put them and package them in the right format.
Yes, Your Honor.
But anything involving
The
search of the house?
Yes.
Okay, what about Duke at Jeffrey's home during the home search?
So Duke being at Jeffrey's home is not intricately tied to the search of that he put it that way, but that's not how it appears in the video. So Duke being arrested at his client's house, we intend absolutely to put it in, and it is not in that portion where she's talking about searching the house. That is just not true. She says they were at his house and they arrested Murphy and they arrested Duke. That part is relevant, and she's gonna talk about it anyway.
Okay, all right. So that's not really kind of germane, I think, in terms of from my analysis at this point in time. Mr. Steele, if she's got a good faith basis to ask that, I think that would be relevant.
I don't have an issue if it's framed properly, asking a witness if it's relevant. I'm saying, why is it on a recording?
Because
I don't think that would, it wouldn't necessarily need to be presented to her on a recording unless it's for refreshing recollection, if she doesn't remember, but we'll see how that goes.
Okay.
But I do agree, anything involving
the search
of Mr.
No,
Williams'
we know
house
better.
is gone. Don't ask her about it.
will not.
Don't play anything about it. And then I'll just leave the other things, Mr. Steele. I'll wait for them to be properly framed in terms of them to be, if necessary, for impeachment.
And Your Honor, what we will do, our preferred method of presenting this to the jury is asked, did you ask him about this? Did he give you an answer? And we'll ask a series of those questions. And after we finish getting those series, we're not going to chop it up. We'll ask a series of questions, and then we'll play the portions of the video that relate to the questions that she did say she asked him and he answered. So I hope that Mr. Steele is not intimating that somehow or another the state is required to start and stop and start and stop and start and stop. What we will do is we will blank out every portion that isn't something that he was impeached on. And we will ask Detective Gaither, did you ask him this? Did you ask him this?
What did he tell you?
Not the what did he tell you, because then they'll say I can't play it through the tape. If she says it through her mouth, I need them to see it come out his mouth. Because if Detective Gaither says it, I've seen it already. They will say, this is cumulative. She's already testified what he said. They don't need to put it in through the tape. I need the jury to see Walter Murphy sitting up there telling them something consistent. The way he said it, his demeanor, how he said it, all of that.
Okay. All right.
Well, and of course, the state's going to adhere to how Your Honor says they have to do it, but I think that's a fair thing to say, but yes, it is my stance that it needs to be chopped
It
up
probably
into
needs to be
individual
played. It
statements.
needs to be played. If you're gonna say, did you talk to him about this? All right, what did he tell you? No.
They will.
No. If you ask him, did you ask him about this? You could,
Yeah, and
no, you're gonna have to frame the question,
I
Ms.
am,
Love, in
that's
terms of, what did Walter Murphy tell you about X?
she will, if she answers that, they have a legitimate objection that there's now no need to play the tape. They have already done it. I've seen the objection. It's already been made. When a witness is asked the answer to a question and we want to play it on the tape, they object. It's cumulative. It's bolstering. We've already introduced it. So, Your Honor, we won't solicit.
All right, well, then you could ask, just a question of, about him like, for example,
Your Honor, we follow the rules. We do follow the rules. And there's nothing in the, we follow the rules. And have,
let me think about it. Why don't you do that? Yeah, you can have a break and I'll make a decision, okay? All right, councilors, this is the last issue in terms of impeachment. Impeachment under 24-6-607 does authorize questioning or should say calling another witness or introducing other extrinsic contradicting evidence. And of course, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters. So, but that evidence that impeaches by contradiction is not collateral can be both substantially admissible as well as admissible for impeachment. So, the court's of the opinion that, if you've got another witness that can testify as to those statements, that they're admissible. All right? So, Mr. Sharp, you don't have to necessarily do that. 607 authorizes that there are 5 impeachment methodologies, so that's one of them. All right? Okay, is there anything else I need to take up? All right, all right, then I will see you all tomorrow morning. For 8:45. And as I mentioned earlier, we'll stay here we'll be here till sometime around a little early afternoon as we have one of our jurors has to leave for an appointment. That's at 3 o'clock, so we'll commence somewhere around 2 or a little before then. All right. So I'll see you all in the morning, okay?
Thank you, sir.
Okay, all right. We're in recess.
May I approach on an unrelated matter? Just briefly.
Rapper and mega producer Sean Diddy Combs' legacy has seemingly